Welcome, everyone, back to my little channel and your favorite little cubbyhole on the internet. It is indeed Friday already. Isn't that marvelous, everybody? Aren't you glad? Aren't you happy? Aren't you pleased that you can give the middle finger to the last 5 days at long last? And because I, can't use all of my fingers because, someone has to push the buttons around here. Someone has to push buttons around there, and that may as well be me. So we've got other people here, too, and that's people like this guy, Jeep Daddy, and also people like this guy. Hey, Rob. Good evening, gentlemen.
Hello,
Thanks for being here.
How are you?
Get that mic close, Rob. We can't hardly hear you.
Okay. Is that better?
That's better. You know what? Think of Laura Owens and Tonsil Twins. Just get right in there. Get it right in there.
Up on in there.
Sorry. I'm being graphic. It's Friday. I can't help it.
It's right.
It is. It is indeed. And there's so much going on. I'm drowning in it because I feel like I'm getting behind, but that's nothing unusual for me. I'm always behind. I'm not the sort that can do this kind of thing every day because I think I'd go crazy. It's just I don't know. I don't know how the regular people do it every day. And
I don't know how they do it either. That's kind of intense. I would drive myself mad.
Rob likes it every day when he can.
I enjoy it. I try to do recordings to pass the time, and then lives obviously are fun too because you get to interact with your audience. I think
Well, it's certainly the more pleasant part of doing this stuff.
Yeah.
Is everyone in chat? Because, well, I mean, that's why I transitioned, so to speak.
You transitioned?
I transitioned from, wasting hours of my daytime life recording and then editing videos to not doing that and doing it all live. I was so paranoid for a long time, for like the first year and a half. Oh, I've got to get every fact straight and I've got to be perfect. The perfectionism set in deeply for the first little while running my channel because, knowing the people as we know them, it's like, okay, I can't fuck up any facts here. I've got to get it right. And if I don't say it right, I need to re-record it and get it right so no one can come after me. And, I thought it served me well. But then I realized how much time I was wasting. It's like, oh, you know what? Hell with it. Just do it. Let's do it live. We're doing it live.
Right.
And then you get it out there. You have some fun with people in chat and other guests. And it's so much more enjoyable than just, sweating in front of a camera and then editing for 2 or 3 days.
Plus, whatever you say, and people correct you if it's wrong. And,
Yes, because we have great people in our communities and many of them overlap. So we've got some smart cookies.
Yes, we do.
We got smart cookies, and I love them. And I love it when they send me little nuggets of information in my emails. There have been some good ones lately. I can't share them yet, but there have been some good ones. We'll see how they pan out. So, and Rob, your latest fetching from the courthouse was delightful.
Yeah, good. You have good.
It's nice to see it in print. We saw the cover sheets, but it's like, oh, look, there it is. Oh, why is his signature a little different on this piece of paper than it is on his bleedings?
For a second, I thought you said his bleedings, and I was like, he's bloodletting on paper now?
Well,
maybe I'm not sure.
I can't tell if it's him bleeding on the pieces of paper for his Arizona bar case or if it's Mark Randazza. I think a lot of it is David that gets, little copy and paste, little tweaky.
Yeah.
But that's a hunch. I don't know factually, but it sure feels that way. It's like this. Why does this sound like David's voice on this Randazza paper? It's very interesting to me.
Yeah, it's almost a blending of, or they're very much alike.
Yeah.
It
is. They may share a brain for some of this stuff, which wouldn't surprise me, but they're such good pals. Such good pals. And I still can't get over that Randazza married another attorney who I was looking to hire for real life stuff.
Wow.
So, circle of life, right?
Yeah, I found an attorney here that I was looking for, and I liked the website. I liked all the description. I liked your skill set and this and that. And then I go there and I go to book an appointment, and it says, I'm no longer taking clients because I'm going corporate job, but I'm referring you to another very established lawyer. Wonderful. It was Randazza.
Oof.
I'm like,
That's funny.
keep looking. I don't think I'd be a client.
Conflicts of interest, I would think at that point, for poor Randazzi.
Yeah, exactly.
Oh, well. Que sera, sera.
Yeah, but he might like me better.
You would have been an easier case, I think, but that's just my opinion as, a legal layperson.
Yeah, there you go. I use layman's a lot, right? The word layman. Like, look, this is a layman's view, right?
Oh, yeah.
Yeah.
Well, and that's, sometimes it's good to highlight that stuff for one's own self-preservation.
Yeah.
Because, well, if we were all experts in this field, we would all be bored to tears. Because they're like, oh, well, that's going to get kicked. Oh, well, judge isn't going to like this one. It just becomes old hat for them. It's like going to work.
Yeah, and watching these cases and how they're continuing on and on and on, but you learn a lot in the process, right? Things are not cut and dry as you'd hope them to be, but you do understand as you follow through the hearing requirements, the documentation that goes through, and I even think judges will ask them to produce a motion. You got to submit one for me to do something for you. You know what I mean? So I've heard that before. Kind of nice.
Yes, I'm not going to do stuff on my own. Submit things, please. Wow, we've got chat just humming away, too. My goodness. Hi, chat. Happy Friday to you all.
Chat.
Including all you new people here who may have found me via Bacon Bears. Welcome to my tiny little cubbyhole on the internet. Well,
Everybody's
I think
favorite.
we're all talking about the same. Everybody's favorite, yeah. Well, I like to think so. I know that's self-delusional, but never mind.
Well, you do. You are sometimes, or maybe more often than not, self-delusional. So
That's my pescatarian nature.
Why don't you just have at it?
I know.
So, let your hair down, relax, kick back, take those sandals off, that kind
It's
of
summer, for God's sakes. Enjoy it. Oh, let's see. So CE Designs, if I can read properly, asks the question, what does Rob think about the DUI dismissal? It's not a dismissal. It's a plea deal.
Yes.
What do you think, Rob?
It was pled down, so the DUI is no longer on the as you described the case. It's a reckless driving case. So it was pled down to that. Now, I don't know about anybody else, but if you've ever dealt with anyone who's passed away from a DUI accident, it's hard for me to believe that someone could get out of that portion of it, at least. So I was a little, put back from it. When I and grabbed them all, I was reading through, I'm thinking, okay, there's a lot of requirements with that plea deal, right? So there's a lot of things that have to happen and cannot be missed even one, or there are repercussions. So although he did not get off scot-free, still, with the Mothers Against Drunk Driving and anybody who's ever had to deal with anybody who had any kind of alcohol while driving, it's not a good situation, right? So I would think that the book would have been thrown, but there was no book.
Yeah.
So
It was a slap on the hand.
yeah.
Terribly unfortunate, really.
Did I hear an ice maker, or was someone throwing marbles down a staircase? Was that you?
I plead the fifth.
Okay, I know it. It's like that's either an ice maker or someone's had a marble catastrophe, or maybe a Lego catastrophe.
No, the only Lego catastrophes that are happening are on a different topic with, in different retail stores, establishments across the region.
I'll bet you haven't been listening to much of that lately either, have you?
I haven't. I have not.
Your very dashing Florida boy has made a number of appearances on his own channel. And his words have not been very. He has not been speaking with honeyed words, shall we say? It's like there may be a hope in Mormonism after all. If there's more people like this guy, you should go back and watch that. But I digress into Legoland for just a brief moment because we haven't talked about Legos in quite some time.
Hey, I've got my.
But I'm trying to keep my pulse on it, and it's getting kind of ugly, especially since Reckless Ben's case will stay in federal court, which is exciting. So there's our brief Lego update. But now at long last, I've got paperwork. I've been. Go ahead.
Real quick, Echoes. A lot of times I'm noticing that the courts are doing more against social media personalities or content creators because they don't know the world, but they feel it's very offensive of what people do and what they are doing, right? So I've noticed that keeping his case and keeping it in federal, it's like if you go back and watch it all from the beginning, you know what I mean?
Yes.
Stuff that wasn't all that appropriate, but
He did a number of dangerous things legally.
but they also accused him of many things that were inappropriate, like damaging the building. All he did was hang a sign from a pole in a tree.
Right.
The damage. I saw that video and I'm thinking that's just over the edge, you know. So I'm just throwing that out there, and I think the officers also have some concerns about social media. You know, it's everybody's right to film and record, so I would hope it gets up to the speed of 2026. You know.
Well, I think that's hard. Like you just hit it right there. It's like people, the courts, the legal system, we see it in legislature and everything else, state and national, that they're not up to speed. They don't understand. Like they're back in the old media world where it's like, it's only like ABC, CBS, and NBC with their big ass cameras and fucking satellite, vans and shit. Like it's not, they weren't ready for, and the laws don't work, with these.
And that's the thing. The laws are not caught up, so the court system can't be caught up. Do you see what I'm saying?
Oh yeah.
Judges only know what they know. Lawyers only know what they know, and they can only current laws are. So if we're going to want change, that's kind of where we have to lead it to, you know.
Mm-hmm.
Is the audio glitching out for anybody else, or is it just me?
I hope I'm coming across. I'm just sitting.
Because every time I don't know. I'm trying to figure out what it is. I lose you, Rob, like it's compressing or something whenever someone else makes any noises. I don't know if it's a StreamYard thing. I know that glitched out. I heard it.
Glitched out a couple times.
Oh, crap. Am I going to have to go out of the studio?
I don't know. Rob and I can hang out and talk about shit.
Damn this StreamYard BS.
Oh, here we go again.
Here we go again.
There are always changes behind the scenes at StreamYard.
There's always problems. It's StreamYard. It's like, do I deal with this for the next hour plus, or do I just pop out and pop in and deal with it? I'll be back in a second. Enjoy, gentlemen.
Oh, that's fine.
We'll talk about your snifters of whatever you have this evening or whatever.
Oh, well, I'll
be back.
I fixed a very appropriate drink for the evening because, we are going to be talking about
gin like you.
Of course.
And yes, and apparently my board decided to freeze. That's cool. Whatever. I don't know. Maybe I don't know. Maybe some planetary alignment's just fucking up all of the stream things. But I have made a gin and tonic because I felt like that was very appropriate. And this is Empress 1908 gin with some the sugar-free tonic in my delightful Waterford Lismore glasses. And I'm just tickled that I have this for the evening.
I'm so happy you're sharing that with us. Not literally, obviously, but
I mean, hey, if you're ever in the same zip code, Rob, I will be more than happy to share a multitude of bevies with you.
Well, we'll see in a few months what happens.
We'll see.
Is that still on?
My Scottsdale trip?
Yeah, I'm ready for the trip, but we got to wait and see until I get the confirmation. So keep that on your radar, Echo. So you got to mention it every stream. Where we at on that Jeep today?
Well, where's my bank account with that is really the question. Because
I told him we need to hire Llama to run a grift for him so he can show up in Scottsdale.
Him and the Mormons, we can run all the grifts.
I think we can make him cry because so many people that they would donate, and he'd be like, "Are you serious? You guys just covered."
People actually like me. What?
You like me? You really like me? They do. They like him more than they like me, and I'm okay with that.
That's just not true. Damn it.
Just not true.
I don't know. I think it's fairly even. But, the repartee takes two to pull off, so there's that.
I'm going for you. You guys bounce off each other quite well, so love it.
Yeah, that's what he gets for saying yes.
Long, and I said I agreed to this.
He stupidly said yes.
Yeah, I was stupid enough to actually agree to this. So he's the dumbass here.
Oh my God, that's it. So speaking of stupidity, Shall we talk about the stupidity of Douche Canoe, or what's his name?
The fucking Douche Canoe.
I've got to get all my buttons in order here.
It's pronounced
Yeah,
gin
that
like
guy.
you drink and grass like you mow.
Gin grass like you mow. Although he doesn't have much of a yard to mow, as far as I'm aware. You know, isn't it? Aren't there cactuses? Isn't that what people have in their yards? Swimming pools
Cactuses
and
and rocks.
cacti.
Well, I assume
Yeah, and lots of rocks.
I hope the roof has been finished by now and it's on the market.
And his what did he call it? The standing balcony? That I don't know.
Yeah,
He was doing tar paper or something. It's like, okay, whatever. That's why I don't like being a homeowner anymore. Too much work. Too much work. It's a pretty good sized house too.
Yeah.
5 bedrooms. Wow. Did you have one just for the cat?
Remember, available on public websites, Realtor,
Yes.
Redfin. Yes, so.
Yeah, well, and you know, other things, other documents that indicate all that information, which are public as well, which I'm not going to get into because I'm sourcing some other documents regarding that little portion of the Owens verse, and I'm waiting for some things to come through from other parts across the pond, and I'm playing some hunches right now, but that's all I'm going to tell. That's all I'm telling chat. I'm not spilling all the tea tonight because I wish to keep my cards close to the vest until I have all my cards. Nice. But yes, I am working on some things. We've got some research going, and it's delightful.
Mm-hmm. Well, you need to clue me into some of that so that I can send robots
I'll tell you later.
things.
Unless your robots can get through paywalls, that may be a problem.
Maybe.
Okay, never mind. Don't reveal trade secrets.
Look, don't. I have people who do this sort of thing, getting beyond security controls as a profession in my back pocket. So we can play.
Well, we'll see.
We can FAFO. It's Friday. Let's fuck around and find out Friday.
We may have to have a special meeting of researchers to coordinate and coalesce their resources and skills.
Yes.
I wouldn't be surprised if Hellville would be a possibility joining the research team for some of the things I'm chasing after.
The tea. Like, I don't know. Like, shit.
Hellville was there.
Amazing.
Hellville was at the trial. So while she wasn't in the courtroom, she was in the overflow with the stupid TV, where they missed half of it because it was just the Zoom feed, which is dumb. So I mean, but she knows some things. She saw some people, and it's a pity she wasn't sitting right next to Megan Fox and her lawyer sister Stephanie, because I think the 3 of those ladies would have had a rootin' good time sitting right behind David Gingras and his antics. But never mind.
Well, I was a lot of fond memories of the day. Tell you that.
I was sort of sorry I was off grid and on vacation at the time, but I caught up. I caught up.
You may have another chance. I'm just putting that out there, I guess.
Well, I don't. I'm having mixed feelings about it these days. The expense not being the least of which. But we know the trial's going to get kicked. Now we're looking at fall, so I doubt it. Well, my opinion is it's probably going to move again, especially since someone's filed for indigency yet again.
Oh, again.
So that we can have free air quotes, experts. And, well, you know what's going to happen with bankruptcy stuff and someone, sucking off of the tit of mom and dad's bankrupt bank accounts. Someone's going to end up dropping their private attorney because he's not getting paid. Just like, what's his bucket? The first one. Crap, I just lost it. Colesrud wasn't getting paid.
Isn't it Looters?
Well, yes, it's Looters now. But, Colesrud was getting a $1,500 there, $1,500 there. And at some point, I think the $1,500 payments stopped, which was when she filed the first filing of indigency happened. And then we got, what's his name? The public defender, who I've forgotten his name too, because, well, he didn't say much. Josh something? No. Whatever. The details are slipping. I can't keep Laura Owens and Legos in my head at the same time. It's leaking, as Jack Fox would say. It's all leaking together. It's terrible.
It happens when you start getting old there, Echoes.
Remind me.
I will.
What? Oh, okay. I blame it on my genetic conditions.
Turn off your hearing aid, Gillette.
Hey!
Jesus Christ.
Hey!
I have done nothing except get pregnant by the fucking bachelor!
All right, that's the tiebreaker.
Christ almighty.
All right, so...
How am I going to put up with you
what?
for the next 30 or 40 years of my life? Well,
It's not like we're married. Get over it. Thank
May as
you,
well be.
Jennifer C. See, this is why it's so much more fun doing it live when we've got smart people in the chat that remember things. Because I'm not going to remember things. Well, I remember a lot of things. I'm just not going to remember everything. And I've given up trying. Number 1 was Colesrud. Number 2 was Swirsky. That's right, Jeffrey Swirsky. I was right. It started with a J. It just wasn't a Joshua. Jeff Swirsky and then Christian Hooters. Take bets on number 4, folks. Take bets on number 4. Place your bets. Place your bets.
Over,
all right,
under,
so.
and-
Yeah, what's the over-under there? Okay, we've got this anti-SLAPP thingy from Randazza with, I'm sure, some input from his client. Because, well, why wouldn't he? And I will say now that while I've got them pulled up, we will be skipping the 3 volumes of exhibits, which total some 800 and I think 50-something pages. And most of it's past history. Most of it's old pleadings from Owens v. Eckerd. It's David not getting his way and whining about it, things of that nature. It just goes on for pages and pages. We're going to skip that. So at some point I'll pull it out of my my tray of tabs and we'll skip ahead because, well, this thing alone, which we've been avoiding for the last 3 or 4 lives,
True.
is 40 pages. But we'll start on page 7.
It's going to be like 40
We
years.
don't need the
really.
indices. It's 7 pages of index. We don't need that. So we'll just start, okay? Some of it's amusing. Some of it's boring. Some of it's lawyer speak. Some of it's just me trying to be a completionist because I can't help myself. But since we've got this little slap fest with the Arizona Bar, because that's what it is. It's an anti-SLAPP slap fest. And someone is trying to take their complaints to the Supreme Court of Arizona because he's not happy with not getting his way as usual. The slapping continues. It's just a bunch of bit slapping. And it's entertaining to me. So we may as well at least, cover the salient parts of the whole thing and weed out the crap.
Yeah, you can't let it drop. I mean, you got to follow it through, man. Right? Whatever these.
That's what I keep telling people. Which is why I'm kind of torn about attending trials. And, there's going to be like 200 people that want to attend this trial. Not his trial, not David's trial, because, I mean, in the end, who gives a shit about his bar case? But Laura's trial, the criminal trial, the 14 felony criminal trial. Unless someone, by some miracle, takes a plea deal. I mean, miracles happen, but psychology can be pretty predictable at some point. And it was very delightful, with great skill using John Cordray's analysis. That was the best.
I did a stream a couple weeks ago on Arizona plea deals. So it was pretty.
Ooh.
I stayed focused on the facts, right? And also on something else that was topical, bankruptcies. I thought, from an Arizona perspective specifically, these are the things that can happen, to expectations. And, a big one that I noticed was they don't like serial filers. Judges don't like serial filers. That more than one. So that was actually terminology. It's like, wow, that was interesting.
Sure. Well, and some of that is interesting when it varies state by state too. So it's just one of those interesting things that can be relevant depending on what case you're looking at. All right. So I'll start reading, and if anyone wants to jump in at any point, you can stop me, and I'll turn it over to you for the reading. But I think, I know I use it a lot for everybody else, but I think I need a voice tonight. I'm just in a little bit of a punchy mood. And it's not that I think Mark Randazza or David Gingras has a squeaky voice. There's just something funny about it. And it has its own inflection and a slight accent that I don't give it, but it does it itself. And it amuses me. Because, that's all I have on a Friday.
Introduction. This case presents an important constitutional question because I, David Gingras, had an important constitutional question. May Arizona discipline an attorney for truthful? That word truthful is doing a lot of heavy lifting, folks. Truthful public criticism of a judge on the theory that the First Amendment does not protect lawyers in the same manner as other citizens.
already.
God. Already in the thick of the bullshit.
Not even a paragraph in. Okay, it's a good thing I don't drink. I would be a mess already.
Well, you are a mess, but that's a whole different story.
I know. Well, tell my team of, therapists and psychologists. And
Oh, okay. All right. I'll get right on that.
the presiding disciplinary judge answered that question, yes. Accepting the state bar's arguments, the court held the protections of the United States and Arizona constitutions yield to the Arizona rules of professional conduct when the speaker is a licensed attorney.
I feel like I need to play the dun dun dun, but I didn't load that again.
My buttons are stuck. I'm having my Rodecaster is just totally fucked up with the buttons. I don't know what's going on.
You've had this problem before.
I literally can't move screens. The left and right arrows to go to different buttons. I can't.
I mean, you've pushed buttons and nothing have happened, and it's just been weird.
Yeah, I can't.
I think you got a lemon.
I'm just gonna redo
K-Dub
it.
says,
This is Echo's real voice. Yes, it is. What you don't know is when I'm talking like this, I'm actually turning off the voice changer. It's so true.
I can confirm.
Oh my God. Yeah, see, even Jeep Daddy will tell you that I'm just a Lego in disguise. Sort of like something from Men in Black. I'm just in this shell of I should have chosen a better host. If I was going to be a little squeaky parasite, I should have chosen a better host. Someone who was at least 5'11" and ripped. That would have been the smart thing to do.
What about
Because I'm not
5'9"
that
and
smart
ripped?
of a parasite.
What about 5'9" and ripped and gingerly?
That works too. I have a range. That's okay. Something more than 5'7" would be great.
Well,
But-
yes, for
but not
you
over
because you're
6'1".
short. You're basically a hobbit. But for me, I'll take the whole. I'll pocket
Not over
K, it's fine.
6'1" though. Tall people, they just hit their heads. Yeah, Rob disappeared. I don't know. I don't know what he's doing. Did he?
Oh, let's see. Oh,
Rob's
lost-
having
I
problems
don't know.
too. I think StreamYard is being a bitch tonight.
it sure would seem so. I mean, and my fucking deck is also being a bitch too. So I'll probably have to switch to just listening on my AirPods for a minute. I'm not going to talk because I know you're going to get all bitchy and uppity about me using my AirPods from my microphone.
Whatever.
Shut up. But
I have stuff to read. I don't care. I've got to get through this.
fine.
thing.
Get reading. Jesus Christ. God.
Stop interrupting. That conclusion cannot be reconciled with settled constitutional law. Although in this case, I think it might be unsettled constipational law, but never mind. For more than 50 years, the United States Supreme Court has consistently, where's that point on my readers? I can't see. Oh, dear. Has consistently held lawyers do not surrender their First Amendment rights upon admission to the bar. Unless you've had a DUI, in which case you shouldn't be admitted to any bars. Subject only to a handful of... What? I see you giving me the stink eye.
Never mind.
Uh-huh. The subject only to a handful of narrowly defined exceptions that have no application here. The bar's position asks this court to recognize a new class of citizens who enjoy less First Amendment protection solely because they are licensed to practice law. Well, if you don't like the restriction on speech, then don't go into law. No decision of the U.S. Supreme Court nor the Arizona Supreme Court supports such a proposition. Debatable. The decision below threatens not only mere petitioners' constitutional rights, but the free speech rights of every attorney in Arizona. This court should not permit that result. As Justice Gorsuch recently observed, lower court judges may sometimes disagree with this court's decisions, but they are never free to defy them. Insert case law there. Jurisdiction. This court has jurisdiction to hear this appellate special action pursuant to Article 6 of the Arizona Constitution and Rule 4 of the ARP for special actions. Special action jurisdiction is especially appropriate here because challenge orders are interlocutory but consecutively resolve important issues. Constitutional law, which this court has held, warrant enhanced appellate review. Enhanced appellate review cases raise the First Amendment issues. Surprise, searches, the matter still not constitutional. Do I even want to read any of this crap? I don't know. The presiding disciplinary judge expressly recognizes this case presents issues of first impression. Well, my impression of all this hasn't been very good. It's just a bunch of antics, the whole thing. Just surrender your bar card license thingy, David, and swim off into the sunset. Swim off into the sunset. Yeah, just go away. Who am I hearing an echo from? Oh, this is weird. Oh, it's Rob. Let me try something. Does that fix it? That's better. Rob was echoing for me in the studio, so I had to turn on his echo cancellation. Echoes has echo cancellation, folks. And sometimes we have to apply it. It's just the way it is. Technology. See, legal case rise and issue statement of importance. Resolution of legal issues. Efficient management of the case. No, equally plain. Statement of issues. We'll skip. Skip. Must attorneys surrender their First Amendment and Arizona free speech rights? Wait. We have special rights to free speech in Arizona. Rob, what do you have to say about Arizona free speech rights? Are they better or worse than, say, Utah speech rights? Ready, go. I don't think they have any in Utah. Point 2. Do Arizona attorneys retain the same First Amendment Arizona constitutional protections as other citizens? And if so, did the state bar establish that petitioner speech falls within a recognized exception permitting discipline? If you just read the goddamn expectations for all the things lawyers have to do to apply to the state bar, you would know what those behaviors are and cannot be. This is not hard. I don't understand this. Did the disciplinary judge err, not but err, like an err or, that longer word with an or, err by granting judgment on the pleadings when material facts were disputed because I, David Gingras, want to dispute anything I don't like and anything I don't agree with, especially in what I did for Laura. I was her hero. She needed a hero. She needed a hero to the common light. He's gotta be fast and he's gotta be sassy and he's gotta be posting all night. I need a hero. Okay, that's enough. Let's see. Erroneous legal conclusion that the First Amendment and Arizona constitutional protections for speech do not apply to lawyers. Does Arizona's newly expanded anti-SLAPP law apply in attorney discipline proceedings? And if so, does it unduly hamper, in air quotes, this court's authority to regulate the practice of law in Arizona and therefore violate separation of powers principles? Ooh, we're getting so fancy in this lawyer stuff. So fancy. Oh my goodness. Okay, statement of facts. Okay, whose turn is it? I think it's Jeep Daddy's turn. Go.
I don't even know if I'm even, I can hear anything. I don't know. My audio is so screwy right now.
Testes. 1,
Can you
2,
hear me?
3. I can hear you.
Ugh, thank God. What? What, Rob?
My was loose. That's what happened to me. So I went out and came back in.
I don't know. I can't get the audio to show up on it. So I'm listening to you over the AirPods, but I can't get it through the main cam.
Your expensive device is acting like a piece of shit.
It's the same piece of shit expensive device you've got, and it's your fault for showing it off to me. So
I haven't had any of those problems.
Mine works just fine, unless I'm being stupid.
Well, I'm not being stupid, I don't think.
I don't know. You've had some weird issues, though, because you try and play sounds and nothing happens. I don't know. I think you got a problem.
Well,
I either got a driver issue, you've got,
I
don't know, you've got a lemon problem.
I don't know.
Squeeze that lemon into your beverage. Well, wait, no, that's a different kind of alcohol.
Maybe. This is a gin and tonic in honor.
Oh, you could put lemon in that, couldn't you?
In honor of our friend.
It's pronounced gin like you drink and grass like you mow.
I don't know that he's a gin and tonic kind of guy. I'm not quite sure what his poison of choice is.
He might be a G&T. It's just a G&T, you know. Rather than not the full name.
Just a G&T.
G&T.
Something tells me he likes his alcohol fancy and expensive.
And possibly a lot of it.
Maybe.
Well, I would think if you, you're fighting some DUR charges and then you plead it down to reckless drive. DUR. I think if he's got some DUR charges.
Who's the drunk on the channel here, okay?
And then, you little whippersnapper.
God.
And then he goes and makes a plea deal. A plea deal. Not a DUI deal, but a plea deal. And please it down to reckless endangerment. No, reckless driving. Well, reckless driving is kind of reckless endangerment.
Oh, my.
It only took a year, though. So
That worked.
It only took a year to get that plea deal, you know.
I'm almost surprised it happened.
All right, where did you leave off and where am I supposed to
Statement
start?
of facts.
Statement of facts.
That would be the top, yes.
Just the facts, ma'am.
Ma'am, I beg your bitch pardon. All right. Statement of facts. This attorney discipline proceeding arises from the respondent state bar of Arizona's attempt to discipline petitioner David S. Gingras for, among other things, his truthful criticism of a Superior Court judge, his petitioning activities, and other speech relating to matters of substantial public concern. Mr. Gingras has been licensed to practice law in Arizona since 2004. The disciplinary charges, see Exhibit 1, blah, 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 stem from petitioner's representation of a party in Laura Owens versus Clayton Eckerd, a highly publicized Maricopa County family court proceeding. Because the case involved a here we go again with all of this. The TV show The Bachelor.
The Bachelor.
Oh, God. The Bachelor. Oh,
Clayton Eckerd, the former Bachelor.
The former Bachelor. Oh, God, gag me with a fucking fork. Okay, former Bachelor star, and you're gonna have to scroll because I don't have control over your screen yet. And extraordinarily allegations of fabricated pregnancy.
What was that? Faggerberry pregnancy?
Faberberry.
That's what I heard.
I don't. Excuse me. Excuse me. While I have
Pardon
a
me.
drink. This is
Pardon
gonna
us
work
while
out
Jeep
well.
Daddy has a Freudian moment.
I'm not allowed to use that word on your stream because you're mine.
I know. I'll probably get canceled.
Probably.
You need the beep button. Beep.
I know.
Beep, beep. And just keep
Oh, we
hitting.
got it.
What you do.
We have all of it. Yeah, exactly.
I know TikTok doesn't like it, but yeah, it's like, oh, well, that's why I don't want to be on TikTok. Never mind.
Yeah, well, there's many reasons why you wouldn't want to be on TikTok. Anyway, okay. Because of all of that nonsense and bullshit, it attracted widespread public attention, excessive social media coverage, and live streamed court proceedings.
Not
Following-
excessive social media, extensive.
Extensive, excessive.
I mean,
whatever.
they think it's excessive, I'm
I'm gonna-
sure,
look,
but
I'm going to make up whatever words I want to use, okay? This is what you get for having me read.
well, okay, my folly, but I can't do all the work.
I'm not as good of a sidekick reader as my beloved Buffy, okay?
Well, she's not here, but you could try and rope her in too.
Well, she's in chat.
Well, she was in chat. No, she is in chat. Yeah.
Anyway.
But, Buffy's
Fine.
got, little Buffies.
Extensive social media coverage. Fine, record corrected. I'm moving on. Following trial, the Superior Court ruled against Miss Owens, awarded approximately $150,000 in attorney's fees,
Not nearly enough.
not nearly enough, against her, and referred the matter for criminal investigation. Mr. Gingras was not accused of participating in or having knowledge of any alleged criminal conduct.
Unfortunately.
That's too bad. During and after the litigation, Mr. Gingras engaged in several forms of speech and petitioning activity that later became the subject of disciplinary charges. This included criticism of the trial judge, communications with law enforcement, and private communications unrelated to the practice of law. The State Bar alleges these statements violated the rules of professional conduct, trademark. Mr. Gingras maintains his statements were either factually true, constitutionally protected opinion, or otherwise protected by the First Amendment, the Arizona Constitution, and Arizona's anti-SLAPP statute.
I don't have any slap noises.
I know, we need some slap noises.
Some slap, like some Three Stooges noises.
Oh my God, wouldn't that be amazing?
Oh, okay, let me write. Keep going.
Yeah,
I'll
write that
down.
down.
Put that on my
whatever
list.
will add it to the queue of shit I got to put on the
Three
board.
Stooges noise.
Anyway,
You need
yeah.
We got to fix yours first.
Yes. Yeah.
I like how it's goose for the gander too. My rights are protected. Oh, really?
Yeah.
But no one else. Okay.
Yeah.
That's what he hopes for.
Hoping.
Rules for thee, but not for me.
For me, yes. Yeah, so Exhibit 2, for those who are curious, I'm not. A principal focus of the disciplinary proceeding concerns petitioner's public criticism of the trial judge in Owens. That criticism arose after petitioner discovered information suggesting that the trial court relied upon facts never introduced into evidence and considered material originating outside the trial record based upon the trial transcript and other evidence. Petitioner filed a verified notice of change of judge for cause, Exhibit 17, supported by Affidavit Exhibit 18, setting forth the factual basis for his concern. The request was denied, number 19 there, but the allegations were not adjudicated to be false. After petitioner filed his answer asserting that the challenged speech was protected by the United States and Arizona constitutions, the State Bar moved for partial judgment on the pleadings, approximate example 3, whatever, number 3. The Bar acknowledged factual disputes existed, but argued they were legally irrelevant because constitutional free speech protections are not a valid defense in attorney disciplinary proceedings. Petitioner filed a lengthy brief opposing the motion, Exhibit 4.
Debrief. A lengthy brief. You know what
debriefs? That's when is that when I take somebody's briefs off? Like,
to go together. It's lengthy or it's brief. Not that. And I think it's petitioner's appendix example. Does that make sense?
It does.
Yeah, petitioner
You're being
appendix.
way too
Indeed.
literal for me.
Well,
Do you see what Buffy says? Look at Jeep
know.
Daddy doing inside sidekicky things.
I mean,
he's a soup. I love that show.
Except in this case, it's the sidekick that drinks, not the host. That's okay, I guess. If
Same thing happened on Johnny Carson. Ed McMahon was tossing left and right. Remember?
That's true.
He was tripping off the chair.
oh my God, that's true, and that
Yeah.
was hilarious. Okay, I guess I need to continue here. The presiding disciplinary judge granted the bar's motion in part, holding petitioner's constitutional defenses failed as a matter of law. Appendix that got removed, number 11. Petitioner later moved to dismiss under ARS 12751, Appendix Exhibit 8. The court denied that motion, concluding constitutional protections for speech did not bar attorney discipline, and further concluding Arizona's anti-SLAPPy law statute could not be applied in disciplinary proceedings because it would unduly interfere with this court's authority to regulate the practice of law. Appendix 16. God, he's had a lot of appendixes removed. What the fuck's wrong with this guy?
Like I said, there's over 800 pages of it.
Jesus Christ. The court expressly recognized that its interpretation of Arizona's anti-SLAPPy statutes presented an issue of first impression that could warrant special action review. Presented an issue of first impression. What? Like, Rob, you're smart. What the fuck does that actually mean?
Issues of first impression. I'll bet Rob actually has an answer.
I'm not saying much.
Okay. Well, it's to put it basically.
Yeah.
And there I go using Jack Fox LY words. Cases of first impression are the first attempt to try the legal validity against a statute or law on the books. So in this specific example, lawyers claiming to be able to say whatever the fuck they want and hide behind anti-SLAPP has not been constitutionally tested and litigated. So this is a case of first impression in their opinion.
Of course. I think myself, oh, look, I was the first one. But it also was updated in December 2024.
Yeah.
It's not like, you know what I mean?
Yeah.
And no one else took it upon themselves to have to deal with this. Obviously, some people think, oh, yeah, I'm going to use that one and get my name out there.
And it seems to me, because I've done a little more digging beyond David Gingras, Vladimir Gajic, another Arizona attorney who got pretty nasty and mouthy, and even right in front of the presiding disciplinary judge, the same one, as a matter of fact, who I think has decided not to renew his bar card. I think tried similar things and didn't get very far. I don't know that he went the anti-SLAPP route. But he and David Gingras kind of connected and said, well, look what they did to me, David. Go get him, David. So, I think David's kind of, trying to rah himself and for this other guy, Vlad Gajic, who probably should have been sued for malpractice by his client. But I don't know if he carries malpractice insurance. Like we know David does not carry malpractice insurance. For obvious reasons, I think.
Well, I'm complimenting Vladimir for giving up his license appropriately.
Well, I don't think it's that he gave it up, but I think he decided to, fight them in the court of public opinion. Because he's got I think he's got a TikTok and an Instagram, and he just goes railing on Rachel Mitchell and calling her all kinds of nasty, horrific things, and her husband, I guess her more recent husband, and also the bar and the presiding disciplinary judge. He just goes full tilt. It's like, I think this guy's a little bit crazy. And he claims, and he hides behind being a veteran, even though he's from, what was it, Slovenia or Russia, or I forget which. Yeah. But, out that way. And, well, he came to the U.S. and fought for the U.S., ergo he's got all these rights and things. And it's like, free speech doesn't give you the right to be a dick.
Right.
Well,
especially in a regulated profession.
One, so that's cool.
Yeah.
Well, and just because one has veteran status doesn't mean that gives you extra free speech protection. It's the same thing that everybody else has.
Yeah. It's not bonus points. Ooh, I get the level 2 premium subscription of free speech.
Yeah, that's right.
Please. Oh, God. Well, if some of our legislators had their way, they would be privatizing free speech by subscription.
Oh, yes. Of course they would.
And that's when we should use our other rights to prevent that from happening. But never mind, lest I digress into
Lord of mercy.
Anarchy.
Yes.
Carry on, good sir.
Okay,
unless
all right,
you're tired already.
Nah, still go here for a little bit with my dramatic reading.
I know. I think Buffy's got to go watch Hamilton, so either be more entertaining or get on with it.
Oh. Shut up.
I don't blame her. I haven't seen Hamilton yet. I'm slightly intrigued.
I haven't either. Okay, let's see here. Petitioner now seeks special action relief because the rulings below hold, as a matter of law, that the First Amendment and the Arizona Constitution do not protect the speech at issue because those rulings present recurring constitutional questions of statewide importance.
Dun, 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 dun.
Yeah, you have to scroll. Thank you. Oh, well, that's
I'm busy watching chat.
Well,
you got a lot to do.
Then give me control of your computer.
Not happening.
Oh. All right. Well, my section.
You are not IT Goatee Brad. You can't just, infiltrate my computer and play with it.
I beg your pardon. I would only do so with consent, by the way.
On both parties.
Touche, Rob.
Well done.
Thank you.
I do, Meowfie B guy. I need staff. Preferably ones that don't want money for right now. If and or when I become so highly monetized, I can pay staff. In which case, I'll just turn this into, like Jubilee or something. I'll have a whole team.
It starts as, it becomes part-time and then becomes full-time. And you're at the beach streaming. There you go.
Yeah.
I put it all out. Your business plan is in place. Okay?
Cubbyhole Incorporated.
That's fine. And when you want to upgrade from the beach, then we'll get one of them Elmo Musk receiver thingy internet whatevers, and we'll be out on the yacht.
Those are fancy.
That I will tow with my big fucking truck because you know I can be diesel daddy from time to time. And yeah, that's fine.
From an undisclosed location, I could be like Art Bell.
You buy the boat, I'll tow.
Oh my God, I could be like Art Bell broadcasting from the middle of God knows where. We're behind the enemy lines in Area 51. Anyone that ever got into Area 51 is, special.
Mm-hmm. Those snuck in and got busted. Those were hilarious videos.
They really are. I could see Jeep Daddy playing the part of Camo Dudes.
Well, I see the video. Jeep Bahaing in the distance, and they're just camera watching him.
Wow.
Wow. I would be very tempted to take. I would like to take my Jeep out on the sand dunes and go see what it can do. That sounds like a lot of damn fun, to be honest.
Definitely.
But for the moment, I'm still chasing mud puddles and rocks. And
that's okay.
Trying to get Echoes to scream like a girl from the passenger seat.
I know you were so disappointed. Oh, IB says they'll call in and talk about aliens. Ooh. Someday when I figure out a little more technology, we may have to do a JFC call-in show.
Oh, wouldn't that be amazing?
For those who wish to use their voices online. It's safer hiding behind a keyboard and chat, but I think it could be fun. Now we'll see if anybody else steals my idea.
You could voice too, so they can call in and doesn't have to sound like them, right?
That's true. I'm sure there's ways.
Yeah.
This thing's got more buttons than I do gray hairs.
Everybody's a chipmunk.
Everyone's got buttons.
Buttons.
That kind of sounds like bacon.
And Buffy, by the way, my Jeep is a diesel. So 2 out of my 3 driving vehicles are diesels. And I
can vouch.
I wanted a diesel Jeep. Very specific. Like I went hunting for a diesel Jeep. So yes.
It is kind of cute how it goes going over the rocks. It is kind of cute. I will give it that.
Chugs its
way
over.
Oh, it's got like a little purr. It's like a kitty.
It does.
Makes up for Jeep Daddy not having any real felines in his life right now.
That's, yeah. I don't. I live vicariously through my friends and my family and...
Buffy's having hot flashes.
Twink number 1.
And IB says,
Buffy,
I need a voice disguise. I want
get out of the deep south and come on up here to Seattle, and I will gladly have you as passenger princess, and we'll have a sidekicks ride out into the woods.
He's got lots of good handholds should the ladies need them. They're everywhere. You can grab the one in front. You can grab the one up top. There's the one on the side. My mother liked to go in cars, one on top and hanging onto the center console. That's how my mother, may she rest in peace, did it. Michael, stop it! My dad liked teasing her in his 4-wheel drive. Don't do that! She had no sense of adventure. Oh, and she was a country girl, which confused me even more.
Huh, interesting. Usually they're a little more open to that sort of thing, but...
All right, carrying on.
Go for it.
Was it my turn again?
I don't know. It's somebody's turn.
All right, well, I'll keep going unless Rob wants to read.
I'll jump in.
Go ahead, Rob.
All right.
Here comes the argument. Special action review is particularly appropriate in free speech cases like this one. This court is repeatedly recognized interlocutory.
Yep.
I wouldn't be able to pronounce that word.
Yeah. Review is especially appropriate where a case presents substantial First Amendment issues. In Citizen Publishing Co.
I like that, Citizen Kane.
This court acknowledged its general policy of declining special action jurisdiction to review orders denying motion to dismiss. Nevertheless, it explained that there is good reason to depart from this general rule when a suit raises serious First Amendment concerns. Citizens Publishing, 210 Arizona, 2005. In cases in which an appellate court can determine from the pleadings a case dispositive First Amendment defense, special action review of a trial court's refusal to grant a motion to dismiss may be appropriate. Such a procedural relieves the parties and the court of a prolonged, costly, and inevitably futile trial and protects First Amendment rights. Quote, and this case presents as even stronger basis basis for interlocutory review, the presiding disciplinary judge has already resolved the controlling constitutional issue and is, as a matter of law, holding petitioner's First Amendment and Arizona constitutional defenses fail even if his speech was entirely truthful. Based on that holding, the parties will be required to litigate the remainder of this disciplinary proceeding under a legal standard petitioner contends is fundamentally incorrect and inconsistent with controlling state and federal constitutional precedent.
That sounds like Randazza.
Yeah.
We'll see if there's a voice change in this.
Got one?
No, go ahead. Go ahead. I'm just wondering if we'll hear David's voice.
Oh, I hear.
Style, you know.
Right, the word. Immediate review is therefore necessary. If the ruling below is erroneous, delaying review will require the parties and the disciplinary judge to expend substantial time and resources litigating aggravation, mitigation, and other issues that may ultimately prove unnecessary. More importantly, the PDJ's ruling forecloses factual development on issues directly bearing on petitioner's constitutional defenses, including the truth of the challenged statements and the factual basis supporting them. Yeah, he's had no part of that. Too big of words. This is the circumstance Citizen Publishing contemplated. The controlling issue is a purely legal one, whether attorneys retain the same constitutional protections for speech as every other citizen, absent a recognized exception. Resolving that question now will protect First Amendment rights, promote judicial economy, and avoid the needless expenditure of resources that would result from completing a disciplinary proceeding conducted under an erroneous constitutional standard. This court should therefore accept special action, jurisdiction, and grant relief. The PDJ erred by granting judgment on the pleadings. The presiding disciplinary judge granted Barr's motion for judgment on the pleadings based upon a single flawed legal premise that petitioner's First Amendment and Arizona constitutional defenses failed as a matter of law because attorneys do not enjoy the same constitutional protection for speech as other citizens, and they're officers of the court. Let's just throw that out there, everybody.
Yes.
Throwing that out there. The legal premise is contrary to controlling authority from the United States Supreme Court and cannot support judgment on the pleadings. Moreover, even apart from that constitutional error, judgment on the pleadings was independently improper because petitioner's answer denied essential factual allegations and asserted legally cognizable defenses. Under settled Rule 12c principles, those disputed factual issues required denial of the bar's motion. A, the bar was not entitled to judgment on the pleadings. A motion for judgment on the pleadings tests only the legal sufficiency of the pleadings, not the evidence. The court must accept the non-moving parties' well-pleaded factual allegations as true, construe all reasonable inferences in that party's favor, and deny the motion whenever material factual disputes exist or the answer asserts a legally sufficient defense. See Delta Z's. Those standards were not satisfied here. Petitioner's answer admitted making certain statements concerning the trial judge in Owens, but expressly denied that any statements were false or made with reckless disregard of the truth.
That's outrageous.
I know.
That's outrageous.
To the blog. Go back to the blog post.
Go back to the blog posts. Someone did those recently. Was it Llama and Buffy?
Yeah, I think they're at that area.
Yeah.
The answer further alleged that the challenged. You want to read this? No footnote.
How's the footnote? Oh, that's right at the end of that one. I do. Let's see. Reckless disregard is shown if the attorney had no reasonable factual basis for making the statements, which he did not. He was making allegations without evidence, considering their nature and the context in which they were made. He was crashing out because he lost and wanted to call her names and then accuse her dad of influencing her judgment.
And
there was no evidence. Zero.
Yeah. He couldn't get out of it, right?
Not even a preponderance of the evidence standard. None was given. Just, I heard someone saying on Dave Neal's YouTube that, Judge Mata's dad was there and he said, Julie, look at this. Come on. Hearsay is not evidence.
Right.
Doesn't even meet minimum standards. Jesus.
Yeah, some of the things
Yikes.
did and said, I wouldn't think would come out of a lawyer's mouth.
Yeah.
Well, it's
baffles.
dingy, after all.
Yeah, well, getting out of the business is probably a good idea at this point.
Yep.
It's the smartest move.
Yep.
Fake your wife's death and get the fuck out.
Do your damage and leave. Statements were either factually true, constitutionally protected opinion, or made with a good faith factual basis to believe they were true, formed after a reasonable investigation. Oh, now we investigate.
Oh, yeah. Well, slap
Don't-
first,
yeah.
investigate later.
Before, but now. Okay, good.
Accuse first, investigate later.
Yeah.
Those allegations alone created disputed issues of material fact and asserted facially valid constitutional defenses. Accepting those allegations as true, as Rule 12c required, the bar was not entitled to judgment as a matter of law. A plaintiff's motion for judgment on the pleading should be denied where issues of fact are properly raised by the answer. Bank of America, N.A. v. Allen. The PDJ nevertheless granted the motion because she concluded those factual disputes. He has a woman problem right there. That's those three little letters. It concluded those factual disputes were legally irrelevant because, in short, truth is not a defense. According to the PDJ, even entirely truthful criticism of a judge may be disciplined because attorneys do not possess the same constitutional protections for speech as other citizens. That legal conclusion is incorrect.
As is the statement of entirely truthful criticism.
Yeah. The PDA's constitutional analysis conflicts with controlling Supreme Court precedent. The state bar's primary position is that attorneys surrender their First Amendment rights upon admission to the bar. No. Over the United States Supreme Court has never approved that argument. To the contrary, each time the same or similar issue has risen, the Supreme Court has rejected it. Where do you get that? Right? I don't understand where you lose your freedom of speech just because you're a lawyer, right?
I wouldn't say it's a loss of freedom of speech, but it is narrowed speech. This is how I would characterize it.
And he says First Amendment rights, so that covers a lot more than just freedom of speech, right?
Right.
Okay.
I think we're grasping a little further to try and make a point.
Yeah.
Oh, you're taking all our rights away as lawyers. We should be able to do whatever we want and not ever have penalties because we're lawyers. You know, this is almost like halfway to becoming, a political officer.
Well,
We want to have the protection of law and none of the responsibility or accountability for violating it.
It's charged language, right? Because if he's going to sit there and say stuff about it's not freedom of speech, it's the First Amendment rights. There's so much that's granted within the First Amendment. It's not just freedom of speech, but this is that sort of dog whistle shit, that comes up a lot. It's the same thing with when somebody says those Second Amendment people need to step up. It's y'all know what the fuck we're talking. We know exactly what you're trying to fucking say. Okay?
Yes.
So stop it. Knock it the fuck off.
Let's remind everybody, and I'll just read this off. The First Amendment states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and petition their government for redress of grievances. The PDJ is not this. Come on. Come on, goddammit. They're not restricting any of those things. Oh, David, I'm making a religion where I can berate and belittle women judges and lawyers.
Yep.
Well, that might be a rough one to sell.
When I've said it before, and I will say
But
it again and again and again,
Getting too
freedom
excited.
of speech or, not having laws abridging freedom of speech does not mean freedom from consequence for shit that you say. You can't scream fire in a crowded theater. That's the obvious one. But you also can't just say whatever you want and have, that against somebody else, because that could be libel. And it just, you can't, it's that I can say whatever I want, but they're framing it in this way that it's like, I don't want consequences for myself because it's so protected under the First Amendment. Yeah, but all they really want is they just want an excuse to say, oh, well, that was my freedom of speech, and so I shouldn't be in trouble for saying what I said. No, bitch, you said something. Fuck off. Like, suffer the consequences. Be the full fucking bitch at this point, okay? Like, if you're going to say shit like that and do that, fucking own it.
Exactly.
I kind of think of it as the bar is like the HR department for lawyers in the state of Arizona.
Yeah, I don't like it.
You've got rules and ethics. You've got codes of conduct that you agree to. And if I'm not mistaken, you also add a signature to when you apply to the bar, if I'm not mistaken. To whine about it now is to try and open up the can of worms that, well, okay, we can't regulate lawyers. Well, then we can't regulate, the HR departments can't regulate conduct of their employees.
Yeah.
I mean, that would lead to total chaos.
Oh, well, yeah. Retaliation and, discrimination and, sexual harassment and everything. Like, oh, well, suddenly they can't recognize that. Well, I guess then we're, Epstein
It's a
2.0
free-for-all.
is going to show up.
Bring back the Wild West where we all meet at high noon to solve our problems.
And an administrative assistant underneath our desks.
The series, the movie The Purge, and the following after movies. One day a year, they get to kill and murder anybody they want. Wow. No, that kind of keeps the population in check. If you haven't watched one, you really need to watch one. It blows.
Wow.
It blows your mind.
Okay, I'll have to have that on the list.
I mean, I know that I would be dead. Like, as much as I have a list of
Oh,
people,
I would have
like,
been long ago.
year,
I've got too
I would
many
have been
enemies.
dead long ago. Like, no question.
I've got too many detractors that you have an axe to grind with me.
You sure do. But I mean, I just think of all the people that I might have like offended or upset or something with something I said at some point. And it's just like,
well, at least you keep yourself private. No one knows your address, what mountain you climbed.
Some of them do.
You'll put it out there.
Yeah, well, they better hope they have done a little more target practice than I have, is about all I should say.
Yeah, we need to go back to that place again.
I know, we need to take some friends with us, too, because people have asked.
Oh, okay.
Did you not remember those conversations?
No, that was too long ago.
Okay, we'll talk later.
Yeah, refresh my memory later. I know that there's a couple other people.
I bother you.
Wait, what was that?
Why bother reminding you? You just forget it again.
Fuck you.
Oh.
Fuck me. Fuck you.
Fuck you. Fuck you.
Fuck you. Fuck you.
Hey, say that.
Bless you. Bless you. Gesundheit.
Oh, yeah, bless
Gesundheit.
you. Yeah, okay. Yeah.
You two are funny.
There's some other people you may meet at some upcoming social events. There are echoes that have also made inquiries about going to said Pew Pew place.
Okay. I'm game.
You would not expect to.
I think I know, because I think I heard them the other night talking about it.
You haven't met them yet.
Oh, okay. All right.
But you will.
All right.
Do you think that WeHo queer would? No. No.
Oh, that's too bad.
He likes axes, but I don't. He would. Okay.
I was thinking of the other one, but not that one.
When you fired my 357, and the amount that you screamed after you shot, after
it wasn't a scream. I think it was a whoa.
Mm-hmm. Can you imagine? Can you imagine him? It
would be like, oh, I pierced the toast. That little thing will kick your ass. That little thing will kick your ass. And that would be very entertaining for me to watch. That will be very entertaining for me to watch on the sidelines.
Somebody needs to be there with the camera rolling at that moment.
Can we bring cameras into that place?
Cell phone.
Yes, I recorded you.
Well, I know, but I didn't bother to look to see if they had rules. With that one.
That wasn't one of the core rules, but
good.
My God. Anyway.
I mean, yes, I knew that you had taken some video of me, but I didn't stop to think of, Do they have rules about this here? I don't know.
I didn't stop to think about it either because it was too fucking funny. And I should have actually gotten the video of you firing the mini hand cannon.
It is. It's a hand cannon.
That would have been fucking great.
Buffy says she much prefers an M16.
Well, I'm well versed with those, my dear. That is, I lived with one for
A long time.
a long time. And I was active duty.
Yeah.
Together with Buffy, she'll be strapped. Don't worry. She'll be bringing her own.
You know, I've got this image of Buffy being, you know, like the seductress in a James Bond movie, and it comes out from the garter and dun 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 dun. That's how I imagine Buffy, because Buffy's got such beautiful hair.
Yeah.
Buffy has always got the gorge hair. Not to say that Llama doesn't, but
No.
Buffy's just, it flows and it just, yeah.
Yes.
She puts herself together well.
She very much does. I wish I could put myself together half as well.
Same, really.
Oh,
Lordy. We've still got some more shit to read, don't we?
yeah, we're only at page 17.
Christ.
Well, B. We did that one
Did we?
over the last
Yes.
50.
Yes.
Yeah.
Next
Okay.
page.
Yeah, all right, yeah.
In Baird versus State Bar of Arizona, the court held Arizona could not condition admission to the practice of law upon surrendering First Amendment freedoms. In Bates versus State Bar of Arizona, the court likewise recognized that attorney disciplinary rules remain subject to the First Amendment. In Gentile versus State Bar of Nevada, the Supreme Court rejected the argument that attorney speech receives diminished constitutional protection simply because the speaker is a lawyer. The Gentile court explained, we have not in recent years accepted our colleagues' apparent theory that the practice of law brings with it comprehensive restrictions, or that we will defer to professional bodies when those restrictions impinge upon First Amendment freedoms. And none of the justification put forward by respondent, the State Bar of Nevada, suffice to sanction abandonment of our normal First Amendment principles in the case of speech by an attorney regarding pending cases. Gentile court further explained that the limited attorney speech case applying different constitutional standards involved only two narrow categories. One, commercial advertising by attorneys, and two, restrictions on information obtained through the discovery process. See Gentile 501. Neither category was implicated in Gentile, so the court rejected the Nevada bar's position and held the lawyer's speech was entitled to full constitutional protection because wide open balancing of interests is not appropriate in this context. Randazza did a really good job on this. I'm impressed.
It at least flows.
Yes, right. Yeah, you can.
It's not a bunch of hyperbolic garbage.
That same rule apply, or bullets, or bolding, or underlines. You know, you don't see a
Yes.
bunch of. Right?
Yes.
Yeah. The same rule applies here. Petitioner speech involved public criticism on judicial conduct and other matters of public concern, not attorney advertising and not confidential litigation information. Consequently, the ordinary protections of the First Amendment apply, just like they did in Gentile. Indeed, courts throughout the country recognize the same principle. The accepted legal principle is that if an attorney's activity or speech is protected by the First Amendment, disciplinary rules governing the legal profession cannot punish that attorney's conduct. See Green and Standing Committee v. Yeagman. Green, attorneys who make statements imputing the integrity of a judge are, however, entitled to other First Amendment protections applicable in the defamation context. To begin with, attorneys may be sanctioned for impugning the integrity of a judge or the court only if their statements are false. Truth is an absolute defense.
Show us the truth, David. I dare you.
Yeah. Bring out the receipt.
Receipts.
Yep.
Receipts are STFU.
Anything. We'll take anything at this point.
Yeah, there's been not even crickets.
No, not even that. Yeah. And you have your crickets, right?
They're not loaded up. They're sleeping.
Darn it.
G Daddy's got his crickets. That works.
Hey.
Now that my buttons are working again.
That's good. Explaining, the First Amendment does not protect intentionally false statements and false statements made with reckless disregard for the truth. Truth is an absolute defense to any statement made by an attorney that impugns the honesty or integrity of a judge. Emphasis added, matter of Anderson 3 Cal State Bar, California, I assume, maybe.
I believe.
Yeah, recognizing like all other citizens, attorneys are entitled to the protection of the First Amendment, even as participants in the administration of justice. Again, this vast weight of authority, the State Bar argued, and the PDJ agreed that lawyers do not have the same or any free speech protection. Who put the or any in there? A court did something that day. According to the bar, this conclusion was implicitly or explicitly supported by matter of James Lawrence Riley, Arizona, 1984. That argument was incorrect, and if it was correct, the court should revisit that erroneous rule. Riley involved alleged misconduct by a former prosecutor who later was elected judge involving comments he made during his campaign. In discussing those allegations, this court cited a 1957 case from Missouri, Woodward 300 SW. Yeah.
You can skip all the legalese garbage.
A lawyer is held to a narrower standard of free speech than a non-lawyer when discussing the judiciary. This court further quoted that 1957 Missouri decision for the idea that a layman may perhaps pursue his theories of free speech or political activities until he runs afoul of the penalties of libel or slander or into some infraction of our statutory law. A member of the bar can and will be stopped at the point where he infringes our canon of ethics, and if he wishes to remain a member of the bar, he will conduct himself in accordance therewith.
Yeah.
That's the whole point of the oath and why you went to school for so many years, right? What's canon of ethics? Do you know, Echoes?
I think that's just, the ethical conduct that they list out. Because this is referencing Missouri. We'd have to look it up.
Yes, okay. So
I'm not sure what their canon of ethics would be in Missouri, but, it's the same as the other codes of ethics. These things are not reinvented. They are virtually identical state to state. There may be some changes of language, but the concepts are the same. About being impeccable in moral character to a certain extent, where you can practice ethically and reasonably, and not be a raging douche canoe tramp stamp of a lawyer who goes out after everybody he can't stand.
The fucking douche canoe.
Now, I do recall he put him out there himself as an internet lawyer, right?
That's how he branded himself.
Why not use his skill set for good and look at what kind of laws he should be supporting or submitting or working on versus going after this way? What can we do to improve the social media work, right? Use your advantage.
Well, considering what he was defending with what's his bucket and the dirty.com.
Yeah.
I think we've got a pretty good idea of what he wants, and he wants the internet and or free speech to be the Wild West.
Yes, open
range.
Yeah.
No holds barred. All things come and go, which I would say could be injurious to society in the long run. Mm-hmm. Because the functionality of free speech is that there are some limits. Mm-hmm. Otherwise, anyone could run around yelling defamatory things about anybody and have zero consequences, even if they are untrue and it destroys that other person's life.
Again, they want the ability to say whatever the fuck they want without the consequence.
Yeah.
That's all. That's what they said. That when they say my First Amendment, that's exactly what the fuck they say. That's exactly what they mean.
Well, like politicians, those nasty mudslinging ads and stuff, repeating things. And you're fine, but the way they present it just makes them look so ugly. You know what I mean? And I guess politicians are fair game.
Yes, because they're public figures.
Okay.
That's been and they're trying to narrow that too.
Yeah.
Yeah, I think there may be an Arizona case with a politician that they've referenced in this.
Yeah, we have
stuff.
No, not. They no less. So these passing comments from Riley and Woodward were harshly criticized in a dissent by the Chief Justice, who warned they were inconsistent with both the First Amendment and the Arizona Constitution. The broad sweeping generalities of these statements cast serious doubt on their constitutionality in view of the First Amendment to the United States Constitution in Section 6, Article 2 of the Arizona Constitution. If the court's opinion has limited itself to statements by the lawyer candidate which were false, misleading, or concerning pending litigation, I could have joined in that portion of the opinion. The holding that a lawyer as a candidate for judge may not criticize the decisions of a sitting judge, however, is neither in harmony with the First Amendment nor with the necessities of a free society. I smell a little DG there. Yeah. Chief Justice Hellman's dissent also aptly noted, under the freedom guaranteed by the Constitution, we must begin with the proposition that like other citizens, attorneys are entitled to the full protection of the First Amendment, even as participants in the administration of justice. Viewer in context it is clear that Riley Court's suggestion that a lawyer is held to a narrower standard of free speech than a non-lawyer when discussing the judiciary was clearly incorrect when Riley was decided. That conclusion is even less debatable today in light of more recent U.S. Supreme Court authority, which directly rejected that holding. Again, Riley relied on a 1957 case, Woodward, which predated by decades later cases such as Bard versus State of Arizona, Bates versus State of Arizona, and Gentile versus State Bar of Nevada. Those more recent decisions from the U.S. Supreme Court firmly reject that concept that lawyers do not enjoy the same First Amendment rights as non-lawyers. In fact, they say the opposite. Scrolling, raw.
Sorry, I'm reading the salacious conversation in chat.
That's okay. I got to sing my song from Blues Brothers. That concludes
Love it.
Yet again reaffirmed earlier this year by Chile in Salazar. There, the Supreme Court rejected the bar's argument that licensed professionals do not have the same free speech rights as others. The Constitution does not protect the right of some to speak freely. It protects the right of all. It safeguards not only popular ideas, it secures even and especially the right to voice dissenting views. Consistent with these principles are precedents that have expressly rejected the notion that professional speech represents some separate category of speech subject to diminished constitutional protection. Chile versus Salazar. In its dispositive motion, the bar never discussed any of this authority, nor did it explain why this case should be governed by 1957 legal standards rather than more recent Arizona and U.S. Supreme Court authority. In short, the PDJ misunderstood and or misapplied Gentile, accurately stated Gentile stands for the opposite premise cited by the PDJ. Attorney speech is not subject to they italicized the word not, but not the word subject. But they're both bolded. Sorry.
Oops.
Stickler, to greater regulation than speech by others unless the speech falls into one of two categories, either commercial speech by attorneys or restrictions upon release of information that the attorney could gain only by use of the court's discovery process. Neither of these categories applied here, so Mr. Gingrass' speech was, like in Gentile, entitled to full constitutional protection. The PDJ's contrary holding misapplied Gentile and must be reversed. C. Any comments before we do C?
No, keep going.
Because the PDJ applied an incorrect constitutional standard, judgment on the pleadings must be reversed. Once the correct constitutional standard is applied, the lawyers do have the same free speech rights as others. The bar's argument fails. Petitioners answer disputes. The truth or falsity of the challenged statements alleges that they were either true or constitutionally protected opinion and raises additional constitutional defenses under both the United States and Arizona constitutions. Those allegations created factual disputes that could not be resolved on the pleadings. By holding otherwise, the PDJ treated the First Amendment and Article 2 of the Arizona Constitution as per se inapplicable to attorney criticism of judges, even when the criticism was truthful.
Boo! Boo!
Run wild in the court system.
Boo! 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 You clean of crime, you queen of filth, you queen of putrescence. Boo! I love that movie. I need to watch it again.
I mean, I'm having flashbacks to Monty Python and the Holy Grail. I've just been reading by, well, the knights who say knee, of course, but just when they're early on, when they're riding by in the horses and like looking for like people to join them on the quest, and there's just somebody who starts like some old bum, whatever, is like, boo, boo, and like King Arthur just gets pissed the fuck off. It's just like, yeah, that's exactly what went through my head right there.
I know.
It is
poor Princess Buttercup.
That is not the same movie. God,
I know, but that's the one I was referencing. And
what's
see,
wrong with you?
Even Buffy appreciated my reference.
Different thought processes, different brains, different memories. By holding otherwise,
yeah, but that's not going to stop me from saying nasty things towards Echoes, because that's what we do here. That's why everybody comes. We're for the entertainment.
Freaking freedom of speech. You got
freedom of speech. Damn it.
Say no more. By holding otherwise, the PDJ treated the First Amendment and Article 2 of the Arizona Constitution as per se, inapplicable to attorney criticism of judges, even when the criticism was truthful. That conclusion conflicts with controlling Supreme Court precedent and improperly deprive petitioner of the opportunity to develop the factual record necessary to litigate his constitutional defenses. The order granting judgment on the pleading should therefore be reversed.
That's what they don't want.
Yeah.
That's what they don't want. They want to drag this out infinitum.
Mm-hmm. Yeah. Then they never have to face the consequences, and they're suddenly going to be dead. And then it's like, oh, okay, well, I guess that is.
I mean, it is sort of fast tracking things with a judgment on the pleadings, but
put on the back burner the state bar hearing, right?
Yeah.
By this, so.
Because otherwise, I mean, they would have to go to a full trial for the whole thing. And I think in the sense of judicial economy, they're like, you know what? Let's just bundle some of this up into some
pretty package.
Yeah, a nice little package of summary judgment.
100 pages worth, no less. Number 3, attorneys do not surrender their First Amendment or Arizona constitutional free speech rights upon admission to the bar. Here, the state bar argued, and the presiding disciplinary judge agreed, that an attorney's admission to the practice of law constitutes an agreement to accept restrictions on constitutional speech rights that would not apply to other citizens. The PDJ made that point clear. I'll stop here. Judge Judy would say this: I can only rule on the four corners of the document. Anything outside of that doesn't matter. So if you sign that thing, you kind of committed to it. Full knowledge, right? I don't care if it's 40 years later. You didn't tear it up. You didn't come to court early in life, right?
That's true.
A person is not required to practice law in Arizona. However, once one elects to do so, upon admission, the person has agreed upon these directives in the rules of professional conduct and restrictions on one's general personal rights. This is original. That proposition cannot be reconciled with controlling precedent. To be sure, Arizona possesses broad authority to regulate the practice of law and to impose lawful ethical obligations upon attorneys. But that authority is not unlimited. Like every exercise of state power, attorney discipline remains subject to the Arizona Constitution and the federal Constitution. See Baird. The rules of professional conduct do not supersede constitutional guarantees. Rule 41 recognizes them as much. Beyond creating ethical obligations, Rule 41 also requires every lawyer to support the Constitution and the laws of the United States and the state of Arizona. It would be an odd construction of that rule to conclude it simultaneously requires lawyers to surrender the very constitutional rights they have sworn to support. The think of the royal family in England. But they live a whole different life, right? They can't just walk around.
Slightly.
Yeah. The United States Supreme Court has also rejected that proposition. In Baird versus State Bar of Arizona, 1971, Arizona refused to admit an otherwise qualified applicant because she declined to answer questions concerning her political beliefs and associations. The Supreme Court, is this McCarthyism or what? Jesus, Lord in heaven.
It sounds like
Oh
it.
my God.
She's a communist. She's a Red Scare. Get her out. Get her out.
Out of here. Get that right out of here.
All us closeted homosexuals in the government don't want her around.
What about Lindsey Graham?
Oh, God, Dennis.
never mind.
He wasn't alone. Well, I mean, what else do you think? I heard a whole thing on that whole story the other day. Not Lindsey Graham, but going back to McCarthyism and all of the interrogations happening in the J. Edgar Hoover building.
Yeah.
Sir, you work for the consulate in France. Are you a homosexual?
Yep.
And it turns out most of those people were closeted homos.
Yeah. He handpicked everybody, remember?
Yeah.
Yeah. I want you to add this to your list. Good Night and Good Luck. It's a George
That
Clooney
sounds familiar.
black and white film. Not old, but it was done in black and white. It's Good Night and Good Luck. And it was during the McCarthyism era. And it was a news
Wow.
Dan Rather type with George Clooney and several other people you would know too. I thought it was done very well, and it was Oscar nominated that year. And it's not that old, so it's not like the 40s or something. Just throwing that out.
Okay.
There was a movie that was kind of a parody of that. It was called Straight Jacket, and I don't remember what year it was. I'd have to look it up. But it's totally like a farce, humor, everything. But it kind of falls into that Hollywood era of people sort of trying to not be gay. I can't remember like who the person was, the main actor.
Yeah, you know what I mean?
But highly amusing. And they did that black and white thing where they had like the main antagonist, like towards the end, that had like, it was black and white, but in, real life, it was like this shade of green on his face and like on his hands and stuff like that. And it made him just look like a fucking creep, but it was supposedly like the way that they could make it look good on camera.
Well, I do enjoy black and white movies because you can do so much. People don't realize how much the gray area and whites and black and all that colors.
Oh yeah. No, I love it. I love going and seeing silent films that are in black and white. Like
Wuthering Heights. I mean, that was just amazing to me. That's just one example, right? You almost felt like you were Citizen Kane. That was done in black and white. 12 Angry Men with Henry Fonda, the original. That was awesome. They had a lot of good actor and actresses in that one, So, believes the Supreme Court reversed holding that although Arizona may regulate admission to the legal profession, that authority is constrained by the First Amendment. The First Amendment's protection of association prohibits a state from excluding a person from a profession or punishing him solely because he is a member of a particular political organization or because he holds certain beliefs. Similarly, when a state attempts to make inquiries about a person's beliefs or associations, its power is limited by the First Amendment. So is that a quote when they do that paragraph like that?
Yes, it should be. It should be a citation.
Verbatim. Basically, it's verbatim.
Yes. Well, I mean, this is why good law clerks are worth their weight in gold to make sure, no one's passing off fake law or law GPT in their filings and pleadings.
Seen that.
But this is the point where it's like, this is just padding the document. We don't need to go into the direction of practicing religion or political organizations because that's not what he's there for.
Right.
This is ridiculous.
Less is more sometimes, right?
Yeah. Well, they're going for the kitchen sink approach.
Well, Jingy
and I hope it
hasn't figured
sinks
that
the
out.
ship.
No. I believe that the judicial system have very smart people.
Generally.
Generally. I think they're going
Well, we found some outliers of the bell curve with this thing, but generally.
You say the duty? What?
What duty? Oh,
I hope he retires soon.
Soon. It's a long time coming. 6 years later, the Supreme Court again reversed this court in Bates versus State Bar of Arizona, rejecting Arizona's attempt to enforce attorney disciplinary rules in Arizona then that habit and tradition are not in themselves an adequate answer to a constitutional challenge. That applies to a lot of things. I always did it that way. Why change it now? Thus, the State Bar of Arizona has twice attempted to subordinate First Amendment protections to its regulation of the legal profession. Twice, the United States Supreme Court has reversed that effort. The Supreme Court reaffirmed this principle even more explicitly in Gentile versus State Bar of Nevada, rejecting the first argument advanced by the State Bar here that attorneys possess diminished First Amendment rights simply because they are attorneys. The court stated, dun, 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 dun. At the very least, our cases recognize that disciplinary rules governing the legal profession cannot punish activity protected by the First Amendment, and that First Amendment protection survives even when the attorney violates a disciplinary rule he swore to obey when he admitted to the practice of law. We have not in recent years accepted our colleagues' apparent theory that the practice of law brings with comprehensive restrictions, or that we will defer to professional bodies when those restrictions impinge upon First Amendment freedoms. That was a mouthful. Gentile. That language leaves little room for doubt. Go for it. I'm sorry.
Well, when you're bored, Rob, you can hand it off. Have you had enough?
Yeah, I'll stop here if you don't mind.
I don't want you to feel like you have to do a monologue for the next 5 hours.
No,
That's
it's
just
good.
unfair. That's good practice, though.
Yeah.
Okay. Oh, let's see. Oh, damn it. Now I've gotten off my page. There we go.
That language leaves little room for doubt. Whatever ethical obligations accompany admission to the practice of law, the surrender of First Amendment protections is not among them. The Supreme Court reiterated the same principle more broadly only months ago in Chile versus Salazar. We're not talking about Chile's baby back ribs. The court again rejected the notion that professional speech, in air quotes, constitutes a separate category. I better not get into that. Entitled to diminished constitutional protection, the Constitution does not protect the right of some to speak freely,
Whose
it
colon
protects
are we
the right
talking
of-
about again? What?
Please
Never
stop.
mind. No, I'm not going to
This is-
stop. Why?
This is not bankruptcy. This is not a colonoscopy. Just leave it alone.
Good. Shut. Don't ruin my night. Don't ruin this.
It safeguards not only popular ideas, it secures even and especially. See, this is why I don't like to read. He just keeps interrupting.
It's fun. Oh my God.
Thank you so much for being polite to me, though.
Especially the right to voice dissenting views, except Jeep Daddy, who needs to be quiet. Consistent
Fuck
with
you.
these principles, our precedents have expressly rejected the notion that free professional speech represents some separate category of speech subject to diminished constitutional protection. Chile versus Salazar. The PDJ's ruling cannot be reconciled with any of these decisions. Rule 41 and the rules of professional conduct, yes, Arizona, must be interpreted consistently with the First Amendment and Article 2, Section 6 of the Arizona Constitution, Triple M Jazz Chat GPT, not as an exception to either. Maybe that's David. I don't know. The PDJ committed legal error by ruling otherwise. We're just going to make claims. Claims and arguments that, poor David. David is being abused by the bar of Arizona. He's not allowed to speak his mind. He can't call Judge Mata nasty, misogynistic things. So bad. Oh my God. My hand is stuck to my forehead now. Do you need some super glue remover? I do. You know, we need an animation artist to do some cartoons for us. We could do some Bricks and Minifigs cartoons, and it would be very good. The PDJ erred by ignoring the greater protection provided by the Arizona Constitution's Speak Freely clause. As noted above, judgment on the pleadings is improper unless the moving party shows the answer fails to raise any viable defense. Well, since David can't come up with any facts, I would say that's not a viable defense. Petitioner's
Facts are
answer.
optional.
Well, you know, if he had facts, he wouldn't have taken Laura Owens as a client.
Yeah, for fucking real.
He doesn't seem to care about facts. That seems to be a pesky inconvenience.
This pesky little nonsense interference bullshit.
Darn this law.
Yeah, damn that law anyway.
Petitioner's answer asserted not only a defense under the First Amendment, because maybe he's Jewish and he's being persecuted, we don't know, but also an independent defense under
Really? You
Article
can get away
2.
with saying that shit just because you're using chipmunk voice?
Yes.
Really? Okay.
Section 6 of the Arizona
Oh my
Constitution.
God.
Well, you know, he's such a martyr. Such a martyr. He
a
could have
cause.
made a good Mormon. He could have said, the bankruptcy. Oh, not the bankruptcy bar. Never mind. The bar of Arizona is persecuting me for my religious beliefs. And that I want to be a polygamist and have many wives. Okay, never mind. David shouldn't have that.
Okay, yep.
David should not have that. He
Yeah,
should.
I don't have the big chicken.
David should not be Joseph Smith reincarnated. He's already had a crack at that many years ago, and he doesn't need to do that again.
Had a
Never
crack
mind.
at something. Okay, well. Never mind. Oh, don't shush me.
I will because it sounds funny.
Don't be a twat. God damn.
A twat.
A twat.
A twat. Who was I talking to? I was talking to somebody about polygamy and David. Oh, God, this is terrible. I have
You
too
really
many
think he
conversations
would-
and I forget them.
You really think that he is got the multiple? I mean,
No, he
no shade-
doesn't.
and I'm
Well,
not
I don't
shade-
think he does.
No shade.
But he
on
would make a good
non-monogamy,
Mormon
but,
because
you know.
of, shall we say, his past.
Well,
You know, he pulled a Joseph Smith and, Helen Mar Kimball-ish.
Mm-hmm.
Allegedly.
Allegedly.
And didn't get prosecuted for it, regrettably. I was talking to someone about that today, but I won't say who.
Was a lawyer?
No,
Was
it was
it a-
not a lawyer. I won't say anything. But it was somebody who follows this. Oh, damn it, wrong button.
The bar, where was I? Commonly known as the speak free code. Okay. The bar nevertheless sought judgment on the pleadings without ever addressing that constitutional defense. And the PDJ granted the motion without discussing it because they think this is just like something we litigate in civil court and we can go back and forth until we run out of money, time, or patience with the judge. That omission alone requires reversal because we say so, as discussed above. A plaintiff seeking judgment on the pleadings must demonstrate that the defendant's answer fails to assert any legal sufficient offense. Did they not read any of the bar and the PDJ's responses? That would require effort. And it's like, oh my God, Laura Owens is getting prosecuted and I'm being harassed by the bar. I should file a harassment case against the Arizona bar for persecuting me, David Chingris, and not allowing me to be a nasty bitch to Judge Mama. I'm gonna be a twat but I can't, excuse me.
See, I have no idea what he says when he
Lord
uses
have
his.
mercy.
I have no. The speed
Rob's
goes up
never
like
going to join us
20%.
on another stream again. He's just like,
I think
fuck
Rob's
this.
enjoying himself.
I'm enjoying
Yes, like I got a couple belly laughs out of it. It was good.
He's like, maybe I should have had another edible before I jumped in the studio.
yeah, right. Yeah.
You should see me when I'm watching and not online. I'm cracking up in the living room.
You don't have to admit anything to me, Rob. It's okay. I mean, God, within like 2 blocks of where I work, there's like 5 edible stores. It's just outrageous.
Well, what the fuck's wrong with why really that close and here you are
Yeah.
like completely like wrung out and crazy.
There's a guy that hangs out in front of one of them most every day, hoping to score some free stuff. It's funny.
wow.
And he plays his music on a boomboxy thing. And he's like, hey, man, can you get me some stuff? It's like, why can't you go in there? He just wants to score it free because he's out there being cool. And, some people do that. But it's funny as hell. It's funny as hell. Unlike some of the other tent dwellers. But never mind, I digress.
Oh, well, yeah, let's
They want
avoid that
wires
level
so
of
they can buy
privilege.
other things.
Oh, yeah. Yeah. Just a little help on their
Just a little help.
Just, anything helps. Okay, well, a bottle of water? No, I need cash.
I tried to
I need money.
submit. I tried to submit an entry to a local group, and I said it wasn't approved, and I doubt it ever will be. If anyone's looking for wire, they may have lost. There's a tent set up here and there that's stripping a bunch of wire. Should you be missing your wire?
Oh my dear God.
For some reason, those kinds of posts never get posted by the administration of such social media, and I think we can guess why, but never mind.
No, they don't.
You know, my social justice warrior has certain limits, and my social justice goes to the point of these people are getting, they're taking stuff from other people to take care of their fix. That's where I want justice to focus on. Because we can't force people into rehab and some other things, like, quite like you used to. It's a problem. Okay, never mind. That's the end of my homeless rant for today.
Oh.
Thanks for coming to my TED Talk. Thank you. Goodbye. Thank you. Bye.
Your TEDx talk,
As
whatever.
discussed above, the plaintiff seeking judgment on pleadings must... Okay, petitioner's answer. Invoked First Amendment, Article 2, Section 6, as constitutional defenses to disciplinary charges. Unless both defenses failed as a matter of law, judgment on the pleadings was improper. Well, maybe it did. Did you actually read? Did you read what they said? Did you read what the PDJ concluded? I'm not so sure.
What's the reading thing you're talking about? I don't understand. What's the reading?
What is that? We don't want to do that. Arizona's Speak Freely clause is not merely a duplicate of the First Amendment. The court has repeatedly recognized that Article 2, Section 6 may provide broader protection for speech than the federal Constitution. Ooh. Sea Mountain, etc. Just a few weeks ago, we're going to try and be relevant in the modern era. This court reaffirmed that Speak Freely clause tolerates no censorship or restraint. Oh, God. And unprotected speech except as permitted by the Constitution itself, and emphasizing Arizona's long-standing commitment to robust protection of expressive rights. And notice all that gobbledygook? I hear more clinking.
Look at that. Look at the parentheses. Citing extensive authority.
Yeah, that word extensive is probably doing a lot of heavy lifting, too.
Not a good word to use, but you used it.
Extensive. Infinite authority. Oh, it's just so weighty. This authority is so long and extensive it hurts my tonsils. Whether Article 2, Section 6 ultimately affords broader protection than the First Amendment under the particular facts presented here is a question this court need not resolve at this stage. But yet we want them to overturn the things they've already decided. So bizarre. The dispositive point is narrower. Petitioner's answer expressly raised the Arizona Constitution as an independent defense because the Arizona Constitution, what am I trying to say? Oh my God. It's like an armored cactus. It's an armored cactus. It shields you from anything in the justice system. It's a impervious cactus. Yet neither the State Bar nor the PDJ analyzed that defense or explained why it failed as a matter of law. Maybe they aren't very smart after all. Never mind. It's so disappointing. I had such hopes for Randazza filings. I'm so disappointed.
Well, his main office is out of Vegas, right? Nevada. So,
Is he?
yeah. He can practice in Arizona.
He's got like bar entrances into 5 or 6 or more states. I forget which.
But I'm wondering if the mindset in Vegas is different around the other countries. You know what I mean?
I wonder. Well, and I know Randazza's gotten his, shall we say, pee-pee smacked in other jurisdictions.
Yeah.
I've read a bit about that lately. He's gotten into
interesting
quite a
spot to
few
come back into the
rows
chat.
or rows with other bars where he was admitted to practice. So it's not like he's a good boy who just does a really good job and everyone goes to him. He likes to stir shit.
Yeah.
He likes to, and it's no wonder that he and someone like Dushkin would be friends.
Mm-hmm.
Seems like an arrogant ass that just, I'm the big dick here in the courtroom now and I'm a free speech lawyer. Yeah, everyone come worship at my feet. Get on your
Maybe
knee.
he drives a big fucking truck. Oh, wait,
I don't
what?
know. I don't know what he drives. I would say if it's not a diesel, it would be disappointing.
He would be a
But he
disgrace
might
to
be the
diesel
sort.
owners.
He might be the sort that drives a dually that's jacked up 10 feet.
Oh, Christ.
I don't know. I just have this image in my head. I know what he looks like, but it's like, what does he drive? No, he's probably got some sort of funny Mercedes that's, it's expensive. I think that's the sort he is.
Oh, a G-Wagon.
Yeah.
Yeah.
You know, maybe he special ordered it from Germany. That kind of thing. That's what I would imagine for him. I don't see him being in a big truck. Anyway, I don't
trying
know.
to be a fancy bitch.
But you know what they say, bigger the truck.
Hey.
Oh, please
Careful, sir.
Don't take offense. It's a compliment.
No, Jeep Daddy shall not disrobe on my channel just to prove anything. That is forbidden. We will not violate those terms of service here.
I admit to having a rather obnoxiously large truck that I have no business owning.
But you didn't buy it.
It's a one-ton.
It wasn't your idea.
Crew cab, 8-foot bed. Well, I did buy it, yes.
Well, from the estate, but it's only because it was a family member.
That's correct.
It's not like I'm going to go out and get an enormous compensatory pickup truck that happens to be diesel. That was your family member that did that. And you went, oh, well, here's an opportunity to have another one, so I'll buy it.
Yes, and I wanted to add to my fleet. Yes. And so now I literally out in the parking lot, which I sent Echoes a video of my blinky lights that I was having fun with.
Yeah.
And yeah, it's fine. That's my diesel daddy. I've literally 2 diesel vehicles out in my parking lot right now, or my parking
He wants
lot.
a third.
I don't know. I think if I were to ever replace the Audi, I would probably, I don't know. I'm really tempted by those Mercedes EVs.
Get an electric Mercedes. There you go.
God, they're amazing.
Don't get a Tesla. Get an electric Mercedes. Do they make those? Am I making that up?
Fuck him straight in the ass. He can drive
I
one of
think
those
there's an
stupid
electric
rolling
Mercedes,
garbage cans right up his stupid K-hole ass. I don't no way.
Oh, forget him. We don't need to talk about it.
Fuck that.
But isn't there, I'm pretty sure, there's got to be like a hybrid Mercedes. I'm pretty sure I've seen one. Unless
I don't want a hybrid. There's I want the full electric one.
Yeah, well,
an EQ that's got the AMG package.
You just got to have the Hoover Dam. Well, don't say Hoover Dam because that's not very useful anymore.
Yeah, no.
You just need the power charging in your.
Well, it's fine.
Yeah,
you know,
your fleet building.
It's okay. I can put some panels up in up on the roof, and that'll just entrench me here more. They'll never move.
Yeah,
be able to find spots to park all this shit.
No, I think you just need to take over like an old hydroelectric project, and you have a house on the bluff, and it's like you've got like the underground bat cave that you have your fleet in.
Ooh, that would be fun.
And you're close to a lake because you live under the hydro project. No, that kind of thing.
Yeah, because you just know that the only reason you want me to live close to a lake is because you want to be out on my boat.
You don't have a boat yet.
I know.
Keep trying.
You need to go out and buy one. I swear to God, I'll tow it and I'll put it in the fucking water for you. Every time. I will do that for you, but you need to buy the boat.
We need to have more rich gay friends we can suckle off of. I need some Hollywood money. I need some WeHo money.
Yeah, WeHo, yeah.
I need some WeHo gay money.
You and me both.
I don't think either of us are pretty enough for that stuff.
I think you're right for OnlyFans.
You know, I think I just borrow Bruce's hooves and I start an Only Feet.
Only feet.
Yeah. Hey,
Only
Feet
hooves.
Finder is real. I've heard that's a real thing. And
really?
Yes, it's a thing. And okay.
Hellville is not wrong.
I have, yes, Hellville is very correct on that because Echoes seems to have a problem with, did you get the magnet package or something where people just wanted to slam into your fucking car every week or something? Like, what the fuck?
I don't know. I think this place is just turning into Los Angeles.
Oh God.
I think that's what's happening. It's just like, oh, this is like GTA 5. We'll just go through every intersection. Woo! I hope I didn't hit anybody going through that red light.
It's Echoes' fault that I spent damn near $1,000 on to equip all of my fleet with fucking webcams or
See, there you go. Cams. Buffy says feet pics is how I make my hair money. Oh, but she's got cute toenails too.
I bet she does.
She does very well because that hair is gorgeous.
Yeah.
Yeah.
Damn right.
I wonder if baby Buffy helps her with her toes.
And look, I'm sure that Marcus would be more than happy to send you tips if you were to post your feet pics.
God.
And he's
You're
not
right. I went there. I just said that. It's fine. I'm here to help you.
Whatever.
I'm here to help you, Echoes.
for Echoes.
He just wants an excuse to bail me out of prison or jail.
After a few days. He's not going to take you out right away. You don't.
No, he wants some sort of debaucherous story he can, lord over me like some sort of weird kink.
Prison love.
I don't know.
Yeah, it'll be a new series. I'll spin up a new channel. Just
with a hidden camera.
Hidden cams of Echoes, hidden cams. Or something.
I better start sweeping my house for incendiary camera devices.
Hey, I haven't bugged your house yet. You haven't let me take over your network and manage it for you appropriately.
Thank God.
You're in your shitty network, whatever bullshit you got going on there.
Maybe I'll keep it shitty to keep you out of it.
No, that's just going to keep me involved.
He's using his neighbor's Wi-Fi.
Yeah, right. Yeah, well, I would like to use his neighbor's something, but he can't.
You leave my neighbors out of this.
No,
they have
I
not
won't.
consented.
Number one, he hasn't had the opportunity to not consent.
He will. I promise.
Shut up.
Accordingly,
Don't
even if
shit
the court
all
were
over
to
my parade.
conclude
Okay,
that
you and your fucking
petitioner's
voice, whatever,
federal
fine.
constitutional defense presented a close question. The unresolved defense under Arizona's Speak Freely clause independently. Wow, that was weird. I heard it in my left channel.
I know.
Under Arizona's Speak Freely clause independently precluded judgment on the pleadings. The order granting partial judgment on the pleadings therefore should be reversed. The PDJ's anti-SLAPP. Okay, this is what I really want to know. Is the anti-SLAPP stuff. The PDJ's order denying petitioner's anti-SLAPP motion rests upon the same erroneous constitutional premise discussed throughout this petition that lawyers do not have the same or any free speech rights as non-lawyers. We're arguing the wrong stuff, I swear, and I'm not even a lawyer and I can see that. Having concluded that attorneys possess diminished First Amendment protection because they are licensed to practice law. No, it's not because they are licensed to practice law. It's because the bar they apply to in which to practice has rules and codes of conduct. My God. The PDJ further concluded that Arizona's anti-SLAPP statute could not constitutionally apply to attorney disciplinary proceedings because doing so would improperly restrict this court's authority to discipline lawyers. Yes, at least we realize some of it. Both conclusions are incorrect, we're going to say. Arizona's anti-SLAPP statute reflects the legislature's determination that meritless governmental proceedings targeted protected speech should be dismissed at the earliest possible stage. See Lucky LLC v. Berman. Discussing newly expanded version ARS 1271 and noted 751, whatever. Noting the expense of defending a meritless case can have chilling effect on First Amendment rights. Courts must therefore act as gatekeepers, protecting the right to free speech from encroachment. I like that word, encroachment.
Encroachment or encrunchment?
Cleaned up. What kind of citation is cleaned up? That sounds like David again. He liked to do things cleaned up, but I'm not sure he did himself any favors.
Mm-hmm.
To accomplish that purpose, the legislature expressly extended the statute beyond civil lawsuits to include any regulatory or administrative action by a state actor, ARS, etc. Although this new provision has never been interpreted by any Arizona court, the plain language of the statute encompasses attorney disciplinary proceedings brought by the state bar. Oh, does it really? I don't remember seeing that when I looked it up. Yeah, now I'm going to have to. ARS 12-754. CJ1. Okay. Biases. I hate legal stuff. It's so cumbersome. Practitioner C 1271. J. Okay. EFHI. Where's J?
Oh, congratulations. You know the alphabet. I'm so proud of you.
I can't find J. This is upsetting. I don't see it. Does anybody see it? There, I'll share it. Let's see. E, F, G,
J is right in
H,
between
I.
I. It's right in between
And then it goes to
I
number
and
1.
K.
Oh, let's see. Okay, J. There it is. 1, 2, 3, J. That's how their alphabet works.
Yep.
For the purpose of this
Congratulations on
section, okay, 1,
figuring out
A,
Sesame Street.
I bet he knows his color.
3.
Oh, God, he's going to be
1,
a
2, 3,
threat.
4, 5, 6, 7, 8, 9, 10, 11, 12.
12.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11,
See, Rob,
12.
he was worried about you derailing this, and we derail ourselves as in classic fashion here on this
say that.
channel.
I participate sporadically, but I love it. If you even know where you're going. Right?
Neither of us know where we're going, okay?
No,
I mean,
That's the fun. It's a journey, not a destination. Okay, so J is for the purposes of this action. J1, legal action. A means any of the following, and then I. Any written investigative demand pursuant to Section 38.431.06 or other compulsory legal process or any regulatory or administrative action by a state actor. It says nothing. It says nothing.
Yep. No association.
No.
I think he pulled, though, into the document.
The plain language of the statute encompasses attorney disciplinary proceedings brought by the state bar. Where does it say that? We've got, here it is. It says nothing about proceedings brought by the state bar and what they just cited. Not at all. I'm upset. I think they're lying and hoping nobody checks their work.
what? Them lying? No, really?
And again, I'm not a lawyer, so maybe I don't understand these things, but I don't see anything referencing lawyers and bar cases and that. That's the anti-SLAPP thingy-majigger.
It's all in the
Anti-slap and tickle.
Oh, well, hey, listen. A little slap and tickle never hurt anyone.
No, I agree.
For once,
That's
you
great
agree.
scenario.
Thank you.
Yes, well, I enjoy a little slap and tickle now and then. Other courts with similar laws
okay,
agree
that's
they
on the
apply
record
in
now,
attorney
okay.
discipline cases. Okay, now we're going to reference other courts with similar laws agree with them. Well, let's see where this goes. See Commission for Lawyer Discipline v. Rosales, Texas Citizen Participation Act, or TICPA, similar to ARS, applies to the Commission's disciplinary proceeding against an attorney. I'm not going to look all this up. That's crazy. Green TCP, skip it. Skip it, just move along. We've got another 10 pages. TCPA was enacted to safeguard the constitutional rights to petition, speak freely, associate freely, and otherwise participate in government. See, there's a difference. There's a difference between being free to participate in state government and being free to participate in the state bar. It's infuriating. The PDJ never... Oh, did I skip something? Let's see. Otherwise, from infringement by meritless lawsuits. Okay, fine. The PDJ nevertheless declined to apply the statute, reasoning that it would unduly hamper the judiciary's authority to regulate attorneys. And I agree. That conclusion misapprehends both the scope of the legislature's authority and the strict constitutional limits upon the judiciary's disciplinary power. To be sure, this case possesses exclusive authority over the practice of law in Arizona. But that authority does not exist in constitutional isolation. The legislature may enact statutes affecting the practice of law and establishing procedures for enforcing rights, so long as those statutes do not conflict with procedural rules promulgated by this court. Promulgated. Nothing in Arizona's anti-SLAPP statute conflicts with any rule governing attorney discipline. Well, we didn't find anything that said it did or didn't. There's no mention of lawyers. Rather, the statute statute supplements existing procedures by providing an early mechanism for dismissing proceedings that impermissibly burden constitutionally protected speech, which is usually what anti-SLAPP is about. It's not a get out of jail free card when you're a douche canoe lawyer who's being a jackass and who's being an unethical attorney, in my opinion.
Opinions.
Because, yes, this
Your
is
First
all
Amendment
opinions. In case you didn't listen to the disclaimer, it's all commentary and opinions. What else do I have other than hernias and painful? Never mind.
Oh, for fuck, real, for fuck, really? Oh my god!
I'm herniating from riding horses, just like Laura Owens. I can't go to court.
Bleeding from all your orifices?
From all my orifices. Well, maybe not all the orifices, but some of them. We'll talk about her in a little bit.
Oh.
There's a little bit. There's not much. I'm waiting for paperwork. There's stuff to say, though.
Okay.
Supplements.
You're waiting for paperwork about your blood from all of your places?
No, I've already
okay.
done that. That was last week.
Oh, okay.
That was last
all
week.
Right. All right.
My doctor's not
I mean,
happy
you're getting
with
up
me.
there. You probably ought to get yourself a colonoscopy.
doctor's
You know,
not
the
happy
camera
with
going
me.
up your hoo-ha and then, doing the thing.
No,
and
we
the
don't like
rotating and
things
blah,
up
blah,
the
blah.
hoo-ha.
Oh,
We don't like anything
you're
up the
asleep
hoo-ha.
for it. It's fine. It's fine. You're asleep for it. It's all right. It's like getting
Are
a
you
date
kidding?
rape.
My insurance doesn't believe in anesthesia.
Yeah, that's true. You've got cheap fucking HMO bullshit.
Oh dear. More fundamentally, however, the PDJ's separation of powers analysis rests upon a flawed premise. It assumed the judiciary possesses inherent authority to discipline attorneys for constitutionally protected speech and that the anti-SLAPP statute improperly burdens or limits that authority. Oh boy. But the Constitution defines the outer limits of every branch's authority, including the judiciary's. But it does not take into account the legislature, you dumbass. Sorry. I'm getting excited again.
You're saying it in French. Dumas.
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 Yeah, what was that movie?
Asshole.
It's Dumas. It's French. I can't remember. Put simply, neither this court nor the state bar has the power to punish speech protected by the First Amendment or Article 2, Section 6 of the Arizona Constitution. At the very least, our cases recognize that disciplinary rules governing the legal profession cannot punish activity protected by the First... Really? Where did that come from? Gentile. Emphasis added. Okay, also green, blah, blah, blah. The accepted legal principle is that if an attorney's activity or speech is protected by the First Amendment, disciplinary rules governing the legal profession cannot punish the attorney's conduct. Case law acknowledges that disciplinary rules governing the legal profession cannot punish... It just keeps repeating. I don't like it.
Cleaned up.
Cleaned up.
Cleaned up.
Cleaned up on pleading to Bob. Prune juice on aisle 2. Prune juice on aisle 2. Like all of the citizens and attorneys are entitled to the protection of the First Amendment, even as participants in the administration of justice. Yeah, well, no one's stopping him from going to church. He could probably use going to church. Let's see, what else? No one's keeping him from redressing his government. I mean, that's what he's doing right here. What was the other thing? Was it the freedom of the press? Yeah, First Amendment stuff. Because protected speech cannot support discipline, Arizona's anti-SLAPP statute does not deprive the judiciary of any legitimate or lawful power. It merely provides a procedural mechanism for promptly enforcing constitutional limitations and protections that already exist. As the Supreme Court recognized long ago, a law repugnant to the Constitution is void. Oh, we're just throwing everything, even Marbury versus Madison.
Oh, Christ.
The kitchen sink, folks. This is a kitchen sink filing.
Per usual. That's on
Per
brand.
usual. I'm surprised it's not 120 pages.
Jesus, fuck.
You know, they could have cited some stuff with Rosa Parks and riding a bus and whatever else.
Mm-hmm. Hey, Night IB, thanks for joining. Appreciate it.
Yay! Good night. Good night. Be well.
Nighty night.
Good morning, good evening, and good night.
She's going to dream
That
of us.
works.
And good luck.
Yes. And good luck.
And good luck.
And good luck.
Let's see. It merely provides a procedural mechanism. As the Supreme Court recognized long ago, law Republic. Okay, I read that one too. Thus. Oh, I love a good thus.
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 That's like right up there with
I say
whereas.
unto you.
It's like whereas, blah, blah, blah.
Whereas and what for?
Moreover. That's
Moro.
Ergo, any disciplinary rule that seeks to punish constitutionally protected speech is simply not valid or enforceable rule. Oh my God. For that reason, since petitioner's speech is constitutionally protected, the state bar lacks authority to discipline petitioner for that speech, regardless of whether dismissal is sought via that thing, ARS, or any other available means. David Gingras has an unfallible, perfect, I'm lost. I lost my train of thought. My little choo-choo has run out of steam. Damn it.
Unblemished. I'm so perfect.
A superlative, eternal truth that you can never stop him from saying whatever the hell he wants.
Oh, wonderful.
Because the First Amendment tells us that David Gingras can threaten Omar Serrato with unaliving people in his family and say the same thing about Dave Neal and face no consequences whatsoever.
Consequences because he's so perfect. Oh my God. And he's infallible just like Jesus Christ. Except Jesus Christ is a bit right there. You know,
but Davey thinks he can walk on water too. Although he did sell his boat, so maybe not. These people who are just so entitled, they take entitled enemas every day, I'm convinced.
Your little chop-chop's running out of steam.
Oh dear. Ultimately, the anti-SLAPP issue arises or falls.
Because Buffy's right. Buffy's always right.
My little chop. Oh dear, that never mind. I can't say what I'm thinking. That would violate TOS.
Sweet Christ. We're at that point of the evening, folks, and he's not even a drinker. All right,
with the
here we go.
constitutional question already before this court, if the attorneys retain the same constitutional protection for speech as other citizens, then the PD's rationale for refusing to apply Arizona anti-SLAPP statute necessarily fails as well, because lawyers are entitled to the same free speech protections as a burp as non-lawyers.
Yeah, keep it classy, even in the voice.
I should have let it go, then I could hear what it sounds like in chipmunk voice. The anti-SLAPP law does nothing more than offer an additional appropriate tool for dismissing claims which lack legal merit. There's a footnote. Supreme Court Rule 49 already permits dismissals of meritless claims to a variety of dispositive readings. Rule 12 being the admission of summary judgment civil rules. Similar method for reaching the same result. Clear and simple man. Anti-SLAPP law thus operates entirely in harmony, not in conflict. Oh, whatever. It's just bloviating. Because it's the appropriate tool for this, the order denying petitioners anti-SLAPP motion, therefore, should be reversed. Ergo, Roman numeral VI, upon granting relief, this matter should be reassigned. This is a request for a change of judge, isn't it? I'll bet. If this court accepts jurisdiction and grants relief, further proceedings will be required below. Under the unusual circumstances presented here, the court should order that those proceedings, be assigned to a different judge. We file a motion for change of judge because we don't like this bitch. And we want to have the right to call her a bitch because she's not giving us what we want.
It's my First Amendment rights to say that she's a bitch.
That's what they are arguing. Let's just call them all kinds of nasty names because that's free speech. And it doesn't impugn the integrity of the court, nor its decorum whatsoever, they posit. I don't agree with it.
I need all of the decorum right now. Thank you very much.
That kind of voice requires an aluminum crotch.
Aluminum crotch?
You know, like Twiggy. What was that show? Twiggy, beep, 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 beep. You know, it's old. I don't remember.
What the fuck are you talking about?
Or C-3PO, he had an aluminum crotch.
Have you lost your... Have you completely lost your mind?
We've talked about this before. I never had one.
Yeah.
Would you prefer the large robot sort of voice instead?
In
we're
ordinary
just moving
civil
along.
action,
I see. Okay, fine.
when an appellate
All right,
decision,
whatever.
we've got 7 more pages. Be quiet.
No, I don't
when
be
an
quiet.
appellate
Fuck
decision
you.
requires a new trial on one or more issues,
What a
the
twat.
successful appellate's right to a change of judge is renewed. I'm going to go to the court and complain. Although the rule has not been incorporated into attorney disciplinary rules, the policy underlying it remains instructive. In King v. Superior Court, this court explained that after reversal and remand for new trial, we haven't even had a trial. Stop it. It is always possible that the trial judge may subconsciously resent the lawyer or defendant who got the judgment reversed. The court concluded the mere possibility. So now we're going to argue all the stuff of why we should have a new PDJ judge. This is so tedious.
The power.
Yeah. He's so right.
Service, I require a legal ejection. It's not an objection. Legal rejection. Get him out. The court concluded the mere possibility of such a thought in the back of a trial judge's mind means that a new judge should be found because they grow on trees. That is, of course, the reason why litigants in civil proceedings are generally entitled to an automatic change of judge following reversal and remand. Although Civil Procedure Rule 42.1 does not apply here. Dear. Appellate courts always possess inherent authority to direct reassignment on remand and, when necessary, to preserve both the reality and appearance of fairness. Because we like to appear to be fair, we don't have to necessarily be fair.
Oh, yeah, no.
Appearances.
Keeping up appearances.
Gotta keep up those
Hyacinth bouquet.
appearances of judiciary or freedom of speech. Keeping up appearances that the judicial system works, at the least. Okay. Sometimes it does, sometimes it doesn't. It's not perfect.
It only works if it's in my favor. Oh my God.
It only works spread all over my face. Relevant considerations include whether the original judge should or could reasonably be expected to have substantial difficulty setting aside previously expressed views or findings determined to be erroneous, whether reassignment would preserve the appearance of justice, and whether it would cause waste or duplication disproportionate to that benefit. C.U.S. v. Arnott. The considerations for favor reassignment here because we are going full Karen in this thing. The PDJ has twice expressly rejected petitioner's constitutional arguments and held attorneys possess diminished protection for speech simply because they are licensed to practice law. God, did we have to repeat ourselves so many damn times?
Yes, they're paid by the fucking letter, apparently. Jesus Christ.
The number of characters and spaces. I hope Randolph is getting paid for all this. If this court grants relief, it will necessarily reject the legal premise upon which those rulings are rested. Not arrested, just rested. Reassignment would permit the remaining proceedings to occur without requiring the same judicial officer to accept a constitutional position she has previously rejected and reaffirmed. Reassignment would also impose no meaningful duplication of efforts. The bar moved for judgment on the pleadings only 3 days after petitioner filed his answer. Oh, boo-hoo. Boo-fucking-hoo. The PDJ resolved the principal liability issues before discovery and evidentiary hearing or substantial factual development occurred. Successor judge, therefore, would not be required to repeat a trial or reassess witness credibility, although they should. This witness is not credible, claiming they're factually maligning a judge when they have no evidence or mastered extensive evidentiary records since none of things occurred previously. Petitioner does not contend that reassignment is necessary as a sanction or because the PDJ acted in bad faith. Rather, reassignment is appropriate. They can't sanction the PDJ, can they? I think we're making things up.
Is that even a thing?
They want to anti-SLAPP the PDJ, that's all.
Huh.
I don't think they can ask for sanctions, though, against the PDJ. That sounds silly.
But they can ask anything they want, right?
I guess. Even if it's stupid.
Right.
That's like the federal government suing the federal government. It's like, what's that going to do? Hello? Rather, reassignment is appropriate to preserve confidence in the fairness of the proceedings following reversal while imposing virtually no countervailing burden. I like all the big words here. If this court grants relief, it should direct that all further proceedings be assigned to a different judge. Conclusion. This case, finally, a conclusion.
Oh, God.
George
Here we
Watson
are. Fucking finally. Conclusion? Yikes.
The game is afoot. Oh, speaking of feet, this case presents a single. The conclusion is 5 pages. This case presents a single fundamental constitutional question: whether attorneys surrender the protections of the First Amendment and Article 2, Section 6 of Arizona Constitution by seeking a license to practice law. The presiding disciplinary judge answered that question in the affirmative, as numerous courts outside Arizona have recognized. Yes, because courts outside of Arizona are controlling in some weird circle jerk fashion. Oh my God.
They do not have to deal with him.
Echoes be bold as fuck with this with this voice going on. Jeez.
Yes. That conclusion cannot be reconciled with controlling precedent from the U.S. Supreme Court. Oh, that's the only one that would matter. The California Supreme Court's not going to be controlling to Arizona, nor Missouri, nor any other state for that matter. This is absurd. This whole thing is absurd. Which has repeatedly and directly rejected the PDJs and states bar position. Although we didn't really cite anything that was accurate to that because it didn't include anti-SLAPP, so never mind. This court should follow suit and reach the same conclusion. Yes, do as we say. Do as we say, PDJ. Because I, David Gingras, I'm an entitled little bitch from California who decided to practice law in Arizona after being investigated for naughty things with minors, allegedly.
Oh, no. Really?
I went into the practice of law to protect ourselves so if that ever came back. So now we want to get our cake and eat it too and lick off the frosting and then put it back in the cupboard.
Wants to lick something, but apparently that's...
No, don't.
You went there. Don't blame. Don't throw this shit back on
no. People.
You don't get to throw this shit back on me.
No.
You went there.
No.
You went there.
Nope, I was not going to David Gingras licking people.
Oh, God.
I don't want to know.
Okay, well, if anybody needs help with a purging station, that's exactly what you need to look for. Put that in your fucking mind and then go in the alley and then, like, purge all those tater tots that you just ate. And
tater tots.
I know, right? It was so good.
Stop it. Tater tots and a little fry sauce. Or I would accept tater tots and some ranch. That would be fine, too. Stop it. I didn't exactly eat dinner tonight. The court should...
What? You didn't?
Well, I sort of nibbled.
You nibbled.
I had a little Trader Joe's, chicken pot pie hand thing. They're okay. Little extra salt, that makes me happy. Threw that in the air fryer and that was dinner.
Oh.
Just Trader Joe's chicken hand pie or something. I forget what they call it.
Chicken hand pie.
I know, it sounds rather offensive, but it's okay. It's very flaky, very flaky dough. It sounds... Yeah.
Marcus is self-conscious. I'm not calling you fat. Oh my God.
What does Marcus have to do with it?
Fuck. No, I'm not.
Oh, you two are going back to your pig thing and him. Yeah, never mind.
Whatever. You're destined to marry him. It's fine.
Well, don't tell that to other people who are interested.
Oh, well,
because the PDJ...
That one still has to pass committee, okay?
He sent me a cute picture today. I'll share it with you later.
Why the fuck have you... why are you holding out?
I'm busy. Because the PDJ's erroneous constitution... I'm so busy. Oh my God, I can't do anything. Because the PDJ's erroneous constitutional premise permeated each of the permeated plus of the challenge rulings. The orders granting partial judgment on plaintiffs' denying and petitioner's anti-SLAPP motion should be reversed. The court should accept special action jurisdiction because we're entitled bitches. Vacate those orders, direct that the matter proceed under the proper constitutional standards, and remand for further proceedings before a different judicial officer that we can bribe into giving us what we want. Allegedly. Never mind. That's just making up. I'm being silly. I'm being facetious. It doesn't say that.
That's my disclaimer. It doesn't say that. I'm just being silly.
Fuck's
sake.
Because this is ridiculous.
Las Vegas, Nevada. That's
Oh,
there.
sure enough.
Yeah.
Las Vegas.
Las Vegas.
Related cases. I'm not going to read it. And then we
Please.
got appendices for the next 800 pages.
Yep.
All right. Well, that concludes that one. Thank God.
Oh my God.
Let's see. That one can go away. Let's click
What
that.
else do you have?
Bye-bye. Let's see. Other things are shorter.
Well, okay. So,
I'm going to
Rob,
get rid
you
of
had
long
said
stuff.
something about you had something along these lines. Like what? Was it all wrapped up into this Randazan blathering about, or
We'll
what?
get rid of volume 1, volume 2, volume 3. Don't need any of that
Let
stuff.
him speak. Shut up.
Oh.
Let him talk.
He can talk. I'm not stopping him.
Requested the records from on the docket from City of Scottsdale regarding the DUI case, but it got converted right to the plea deal, so I got a copy of that. And I don't know if you've got that online. I'm sure I sent it out so people posted.
It's on the Twitters.
Oh, because I have your email.
It's on the Twitters. Let's see. Has it? I don't think it's gone to Volo yet.
Okay. It
Because
might.
usually they're really good about linking it to Volo when they've got it uploaded. So I don't think
Yeah.
that's happening. But I've got it on the Twitters.
Okay.
Let me bring that up.
I'll title it D.
In the meantime, Marcus, what do you spent $150 on a box of rocks? Can you
That's
please
expensive for
clarify?
rocks.
Can you clarify what you mean by that? I'm really confused. Why? I mean, I've spent $150 on some really shitty decisions. Not gonna lie, but
10-minute video for a box of rocks? Ooh. Maybe they're polished rocks. Those can be expensive.
we used to do that. We used to get the little polisher thing, and like you could put rocks in it.
The
and then,
tumbler?
like, yeah, it was like a little tumbler.
I
and you
always
put it
wanted
in.
one of those when I was a kid, and I never got one.
We tried one back in the day.
You know how to make rock candy? Don't build.
Rock candy. Sounds like Pop Rocks.
Kind of,
It-
yeah, pop rocks.
Hard rock candy, pure sugar on a string.
Oh
And they-
God,
I've not made that.
Yeah,
It
it's
sounds
good.
like fun.
that sounds like
I think my
diabetes
doctor
on
would
a
disapprove.
string.
Yeah,
My
your
doctor would disapprove.
diabetic would not like this at all. It's not a,
My doctor would disapprove.
yeah.
My,
Yeah, I just-
my entire medical staff would probably fucking disapprove of that. But holy shit.
No, they would confiscate it themselves.
So, did he file to seal this case? Is that what some of this is?
It's out there, but this is on the court docket, so it's available as far as the rest of it goes.
Fulfillment of conditions of probation or sentence and discharge by the court. You may apply to the court where you were sentenced to have the judge's judgment of guilt set aside. You may be eligible for a certificate of second chance. You can file the application. Okay, interesting. I've received the notice of right to apply to have the conviction set aside. Well, he took a plea deal, so they can't set it aside, right?
Yeah.
Let's see what else we got here. Something that's really small and really light.
Yeah.
Ew. Well, it's hard to read it. I'm not sure I can. And it don't get no bigger because it's Twitter's.
Yeah, right.
Amended court for court.
You an
$500, $1,000 something and 41 cents. Substance abuse screening program. The defendant shall. God, it's really hard to read.
Skip this one. You'll see another one.
Yeah, if it gets to Volo, it's probably going to be easier.
Or
Then I can embiggen it.
Yeah. The judge's first name is K. So
Okay.
he asked all these questions of DG and lawyer to make sure that they understood why he's accepting the plea or going for the plea deal. And at the bottom, he said, yes, he does seem intelligent enough and alert, whatever the word, right, that he'll accept the plea deal. That's a judge. On the basis of these findings, I conclude that the defendant knowingly, voluntarily, and intelligently pleads guilty to the above charges, and I accept this plea.
I'm disappointed in number 5. If arrested on subsequent offense, defendant may be charged with a more serious offense and associated penalties, which include, with the appropriate underlined tick boxes, loss of driver's license, restitution, MVD, ignition interlock, or other. But That, of course, says non-applicable.
I just pray he doesn't do it again. You know, don't be on my roads and think that you're okay to drive. We've watched way too many YouTube videos. People aren't there. They don't know.
When he came after me the previous time he decided to come back to the internet, I said, I hope you come back with an ignition interlock device. I don't think he took too kindly to that.
It's a good
But it's like,
tool.
well, come swinging at me, I'm going to be a little bit more blunt with you.
Mm-hmm.
Especially after you've been charged with DUI offenses. Yeah, it was a whole exchange. It was before the death.
Yeah.
And he was throwing stones at all kinds of people, as usual. Let's see. Court has advised defendant. Yeah, so this is just all the acknowledgement.
Yeah.
Yeah, it's a lot of, have you done this smartly and voluntarily and blah, 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 blah.
Smartly.
Of your own free will and satisfied with the services of their attorney. Well, that's good. Constitutional rights. Yeah, so it's just their rights. It's just a rights acknowledgement thing. We see those.
This attorney's address is literally around the corner from the courthouse. He's that
Oh.
close.
Huh. Wow.
75th Street.
Lives at the courthouse. See, conclude if knowingly voluntarily. That's the phrase. Knowingly, voluntarily, and intelligently pleads guilty to the above charges, and I accept the plea. And then this defendant response. Okay. Then that's signed. Then the minute entry, it's ordered defense attorney's motion to accelerate is granted. Contact report, monthly progress report.
This was for Scottsdale Treatment Institute, where he needed drug and alcohol education. So there's a 6 requirement.
It's unfortunate. Its acronym is STI.
Right.
Right.
Sorry.
That's okay. And then it also listed
Somebody
as,
should have thought about that one.
which the scheduled intake was May 18th, but if you notice, everything else was on May 22nd. The plea
Yeah.
date. So then it's supposed to be completed by July 18th, which is just last week or two, right? So I couldn't find any final report. I assume it was taken care of.
For completion.
Yeah, because you would think
Yeah.
you definitely.
I think they would, and maybe that goes. Who would that go through? He doesn't have a parole officer, so it's not that.
He
Or his
posted.
representation, I suppose, would present any certification that he completed. I would
Right.
think the court would require it.
Right. And this company allows Zoom calls
Oh, well, how convenient.
to your own home if that's what happened, but they do offer that, so you don't even have to leave the comfort of your own home. And again, 75th is a courthouse, but this place is on Hayden Road, so it's a little bit further from the courthouse, off the 101.
The notes at the bottom are salient, which says client has been screened and is assigned level 2, 16 hours of alcohol/drug education. It's not very much time. It's a few days. If you want to spread it out. I don't know how they package it.
Well, that's
Program is to be completed no later than 7/18, just as Rob just said.
Yeah. So that's a 2-month window. And I assume it had already been taken care of well before all the other things go down.
But he was also gone for a little while.
Yes.
If
I would assume most of June.
Yeah. Okay, that concludes that one. 2 of 2. Oh, what? What happened? Did it go through all of them?
Yeah.
Okay. Yeah, I guess it did. I only clicked the first one, but it went through both pages. All right. Perfect. Very nice. So there's more about the DUI pleading. I don't know what you call it. The douche canoe DUI pled down to not so DUI.
Right.
Damn it.
Yep. So the DUI is not on his record, and nothing came of that. Which, if anybody knows anybody driving, it's not something most other states, right, throw the book. So I was a little disappointed, I guess.
Yeah, and it's not his first one either.
That's true too. And I pray it's his last. You know, I'm just saying, because it could be worse.
You know, some states have 3 strikes, you're out, but I don't think Arizona's quite so punitive when it comes to DUI.
Not if you can plead off it. Wouldn't that have been to it? Say, no, that one we're sticking with, you know, I would think.
Yeah, and didn't MAD get involved too?
Yeah, they were monitoring the case. They don't get involved with any of the decisions.
Okay, that's the phrase, monitor the case.
Yeah. So that was good that they were
Do they
involved.
ever file things like amicus briefs in cases, or they just stay out of it altogether?
Stay out of it altogether.
That's very interesting.
Thing is really, really off, then they'll step in or something.
Well, maybe it's because they don't want to pay a lawyer to get involved. Which I don't blame them. I mean, they probably intake some good support funding, but...
Yeah. Yeah, like I said, I hope the education helped. I hope that it doesn't happen again. I hope he moves out of state sooner than later, personally. That's just my want, wish, whatever.
Yeah.
And, you know, we'll see what the future holds. I don't see holding him here, you know.
So,
I don't think he's going to hang around in Arizona much longer.
I really don't think he's going to be there that much.
As soon as he gets to bounce, he's going to be out. Now the question is where will he run? California or someplace else?
He shut down his law practice. I kind of assumed that was the finale of his time in Arizona, and I'm going to assume California because that's where some more of the Owens people exist, and
But just to close the law practice doesn't mean he gave up his license. So he can still practice law, right? So keep that
fair.
Yeah.
Yet.
For who?
If he loses it in Arizona, I hope to God there will be some reciprocity in California.
Yeah, that's a good idea. The word gets around. So yeah, it would be difficult for him to just move to Cali. But if I'm not mistaken, his parent lives in Florida? Or
Yeah, his mother.
Okay, so Florida.
Hmm.
So that could
If I recall correctly, that's where she
and
is.
correctly too. So that could be another place to go to, you know, which he's not licensed in that I'm aware.
But he's been pro hoc viced into a thing or two down there.
Mm-hmm.
I forget that case with that other guy. I looked into it and went, I'm bored with this one. Not interested in what else David's doing.
Yeah, right. I just feel bad because based on my impression of him over the year, 2 years, 3 years, whatever, he's gonna have something else to bring to light. You know, just like his ex account, just like something, he's got to keep going. I'm praying that he does it. You know, like just let it be gone. You're done.
Well, he's got to have something. It's a similar thing, like I've said before, with the researchers and like black hat hackers and that sort of thing, and like InfoSec world. It's like there's a thing that it's not necessarily about maybe the monetary piece of it, or the whole idea is I just want the notoriety.
Yes, that's the word I was thinking too. Yeah,
and the way that all of these legal briefs, the thing that like my brain is latched onto with each one of these things over time is it's all about, they keep referring to, it was about the Owens and the Bachelor and Clayton Echard former thing. Like they're desperate to hold on to this thing.
Right.
And
you want to keep associating yourself to something.
Right.
Right. Because that's a whole different planet, you know.
Yeah.
Just based on the public information.
It's like, I don't think he's going to, like, much to everyone's chagrin, I don't think he's going to fade into the background like we kind of hope that he does.
He can't and he won't.
He can't because
he's too much of a narcissist.
His ego can't let that shit go.
Yeah.
Even if he does all of this shit pro bono for Laura and whomever else, like he can't help himself.
And I thought that he could just, give up his license and this will all be done. He could move on. But I guess when there's an active hearing or bar charges, you can't just give up your license. You have to go through the process.
Unlike bankruptcy, where you just hope you can dismiss it once you get caught with your pants down, I think it's a little more difficult with a practicing attorney standing before the bar.
Look, it was a skeleton filing.
It was a skeleton filing. We didn't have an attorney.
Until you needed something and told me I needed to provide it, I'll provide it. But don't expect me to all up front.
But
Queen Jennifer, don't expect things from us. We don't have an attorney. And as brilliant as I am, a legal mind, being Jan Black, Elizabeth Ann Naylor owns, I am not an attorney. So you're going to have to give me the roto-rooter up the hoo-ah and look into my stuff. You know, I sent everything to you, Queen Jennifer. You just need to dig through all the bank stuff. All the bank receipts and all of the invoices and all of the other bank things. But, you know, don't touch my GoFundMe, goddammit. Don't touch it. It's mine. It's for Laura. I mean, it's not for Laura. It's for our needs.
It's Ron's
It's for our
medical
needs. You know, Ron has been through such a hard, challenging time. He's facing such personal problems. Never mind Laura. She doesn't... As far as the GoFundMe is concerned, Laura doesn't exist. Oops.
Look,
these people.
Echoes, your boyfriend's going to bed.
That's good night.
Night.
Whichever one.
So,
My
You know
harem of
which one.
boyfriends.
Oh my God, how dismissive of you.
I know. I shouldn't be so dismissive. I'm not trying to be insulting.
so
No,
August,
it's like here's the bankruptcy button.
but
That was easy.
I'm telling you, we need to make some bankruptcy buttons. That'll be my first merch store.
This is
thing.
all it is, right here. It's the red
You,
button.
you push
We're
the red
not
button and go boop, and it all goes away.
Yeah.
Boop, bankruptcy. It all goes away.
Gone.
where did I hear that before?
I should make that a sound bite. I haven't done it yet.
Yeah, that'd be a good.
That would be.
Thank you for using
Okay,
the-
bankruptcy. And I go. I've got that clip that I like to play, but I need to grab that one just itself. Let's see, douche canoe, bankruptcy. It all goes away. I just need to get that one little chunk.
Do you think that the judge will dismiss the case based on Jennifer's recommendation, like she did last time?
I don't think so.
I think the judge is going to want more answers, right?
She really wanted to dig into it at the last hearing, and Queen Jennifer was ready just to kind of let them ride off into a year-long furlough from being able to file bankruptcy, but the judge was like, no.
You don't
Especially now that we know about a GoFundMe thing and a smear campaign.
Yes.
at least
And then
AFC. Well, I guess that's the new acronym. Like
what's the new acronym?
the smear campaign.
Smear. Yeah, that's the
Yeah.
new thing.
JFC.
And what came out of that 341 hearing sounds like an absolute shit show for them. So my thinking, unless something goes funny in the August 6th hearing, is that it's going to get converted to a Chapter 7. And then we're really going to do some digging.
So what does that mean? They don't
When it gets converted?
converted, yeah.
Tiff explained it a little bit.
Okay.
But essentially, they restructure it as a Chapter 7 so that then they can sell off the stuff and they can do some more digging into the finances because the numbers don't add up.
Oh. It's
So
not
really,
house and not have to pay any debt or anything, right? It's not
well,
that.
no, they would still have to deal with the house, especially now that we've got creditors showing up on their doorstep.
Yeah.
Colt Mortgage with the $1.7 million mortgage loan that I jokingly referred to as the horse loan yeah. They're knocking at the door now, and there's apparently, according to the Twitter today, there's 14 others, or 13 others, of which they were number 14.
They were invited or whatever to be attending, but they didn't attend. And now they're just getting down to the wire. Now they're coming out of the woodwork and claiming what they want to claim, right? It just makes sense.
It does. And I suspected that would happen because of when the court sent out the notice of the dismissal. And the judge was saying something about 20 days to respond. So this is falling within that time frame.
Gotcha.
So I was like, it's a little early to be, and I was kind of surprised that Jennifer was, there aren't any creditors at this hearing, which is odd. And it's like, well, they're slow for whatever reason.
They're by time. They're like, well, why come to this? Because there's going to be another one and another one. And now that we're getting close to the end, so to speak, right? So I think they be much more in attendance.
Yeah, I'm slightly disappointed we're not going to get a 2004, but I think the next hearing in front of the judge is going to be exciting.
So let me ask you this. We didn't need a 2004 because there's so much information that went on in
That came out of the 341.
Do we
So
need
that's
it? Think of it that way. Like,
that's why I think it's going to get rolled over into a 7. I don't know if Tiff would agree. She probably would, but I don't know. I'm not going to put words in Tiff's mouth, but I think that's where it's headed, and I hope so. Because otherwise, then it would just be the judge lost interest. It's like, okay, fine, whatever, get your dismissal. I don't think so. Especially after that 341 that went on for almost 3 hours.
And the word, what was it? Contempt of court was mentioned a couple.
And fraud.
Mentioned.
I mean, I believe there is plenty of evidence of fraud. Plenty of evidence. And, that was the other thing. Where's that? I saw that scrolling through the Twitters today, too. Oh, where was it? There was an article that said Ron Owens pays 10% over what he makes for everything. And I'm like, that went back to the 1970s. And I went, of course.
Yeah.
This is a habit for them. Oh, there it is. There it is. There it is. There it is. Share this tab. Boink. Click different buttons. Boink. Nope, not that one. That one.
Yeah. Oh, sorry.
Let's see. Ron Owens told the San Francisco Examiner, 1976, I spend 10% more than I make. Owens, in many instances, isn't your typical broadcaster. Oh, much of his background is familiar. A page at ABC for $1.35 an hour, New York. 5 radio jobs in the past 8 years. A divorce. So he was married previously. And a swinging lifestyle in which I spend 10% more than I make. Isn't that interesting?
Swinging lifestyle.
Isn't that interesting? Yeah. And here's the article. San Francisco Examiner, Sunday, March 21st, 1976. Not the best picture of him, but never mind. I don't want to read it per se. Other people can jump on that one. Let's see. Where does it say he was at? That was always a curiosity to me.
Was it in the... always in the Bay Area? Because if he was in
No,
Europe,
he got around. Because he went to Temple University as memory serves.
At Studio 54 at some point.
Maybe. 5 radio jobs, divorce. In other words, he's atypical. He's a New Yorker who doesn't like New York.
New Yorker.
He has a BA with honors from Temple University, in sociology, and almost picked up a master's in communications before he got bored with his thesis, which he didn't complete. He also taught 5th grade, oh, that's scary, in Philadelphia for a year and year and a half before he finally decided there was only one interest for him, radio.
Was this an article to rip on him or just factual?
I don't know. Should we keep reading? And for him, KGO is the pinnacle of talk show radio. Oh, God. Really? Not even the largest market in the U.S. Not even close to the largest market in the U.S.
CKLW in Detroit. That's what we like.
Jeez Louise. I think I've always pointed for this station subconsciously. End quote. He reflected over a glass of white wine. Oh, that's nice. It has been... It has the best talk show reputation in the country. It's responsible and it's respected. Okay, fine. In Ron's last job, it wasn't that way. He was hired by the 25,000-watt daytime station, WRNG, in Atlanta as a Yankee liberal smartass for the afternoon drive period. I like that. The morning drive time was occupied by a supposedly redneck Southerner. The extremes grabbed Georgians. But here, he says, I can be less sensational and more substantive. Oh, God. I see where Laura takes after him now. A little bit.
Yeah.
I have a podcast with my mother so I can talk about deep subjects.
That makes me an instant expert.
I am just a podcast horse girl guru. I love self-help because self-help helps me. Okay. See, what I love about KGO in San Francisco is that I'm overpowered here. What? I'm used to leading my listeners, but here I'm being led a little. I'm mellowing and more able to understand the other side. Maybe it's the maturation process. Conceivably, it could hurt me, but since I adopted that other style for effect, I'm much more comfortable being genuine. As an example, he cited the issue of busing. Busing? Is that what it says? I think so. Gosh, it's a little bit hard to read. I don't think it'll get any bigger. Oh, maybe it will. Okay. I like bigger. That helps me. He was initially in favor of it. Now, however, he has come around to the view my audience helped change it, and it's not in the best interest of those involved if those involved are opposed to it. I still believe what I believe, says Ron, openly admitting I'm dogmatic, opinionated, and at times abrasive. Red flags. But now if I make a mistake, I'll say so. If I'm wrong, I'll admit it. Yeah, right.
Yeah, right.
Times have changed.
There's no sin in changing your point of view. We've had too much of this macho thinking process where views become as solid as rock. Well, times haven't changed there. Yeah. Owens isn't preoccupied with the serious side of life. He does incredible imitations of Howard Cosell? Is that what it says?
Howard Cosell.
Oh, there we go. Okay, thank you. I can't quite read it. And Richard Nixon, among others. Oh, well, that's flattering.
Who can?
Yeah. Right. At his Pacific Heights apartment, he has an answering device on which he tapes greetings for callers. Of course he does. I can do voices. It's my skill. Phone Ron and Jimmy Hoffa seems to answer. I'll call you when I get back, if I get back. Or Nixon. Thank you for calling me. Nobody calls me anymore. If I don't get your message, it's probably the tape recorder. It skips for 18 and a half minutes once in a while. Okay, he's got a sense of humor. I'll give him that. Owens is also an expert in rock and roll trivia, who recorded the hit record Locomotion, Who Cares? Well, says Ron, it was Little Ava, the babysitter of singer Carole King. Little Francis Scott Key. Little Ava had only one hit. The last hour of every Friday night is devoted to this nonsense where absolutely nothing serious is discussed, says Ron. It's for an admittedly selfish reason. It gets me in a good mood for the weekend. During the weekdays, he gets to bed at 2 a.m. That's a late night. Wakes up at 7 a.m. to get to the Chronicle to read Kane and Doonesbury, then sleeps to 9 or 10. Each Wednesday, KGO provides a packet of a dozen periodicals, People to Popular Science, which he reads, knowing 99% of the information will be extraneous. But anything you read has to be beneficial, he believes. Since October... What about his daughter's Medium blogs? Since October, the salutary effect of the autumnal Bay Area weather and San Francisco's benign attitude in New York, people don't care what you do because they don't have time for you, has further increased his affection for the city. I had high expectations for the city, he says, and all have been fulfilled. The same might be said for Ron Owens. And then he ascended into stardom, as if by magic. Interesting stuff. Oh, let's see, and then I've got a couple other things, which goes back to the anti-SLAPP stuff. It's just talking about the PDJ, blah, blah, blah. First impressions, wanting special action. What's this one about? Status report. Status of... Yeah, we're just pushing that this is a case of first impression. Order granting state's bar motion. Both orders contain same legal error. So now we're repeating ourselves after the long thing. Oh, look, there he is. Douche canoe. See? D-O-U-C-H, and there's the big C, canoe. As a respondent further notes that although PDJ is not a party to special action, Supreme Court clerk will serve PDJ with copy, blah, 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 blah. Okay, it's needless garbage. I don't like it, I don't need it. What's this thing? Supporting document in order for partial judgment on the pleadings. Oh, who's this from? Oh, is this from the bar? Oh, it is. Oh. Should we read stuff from the bar? What time is it? Oh, well, gosh, it's almost 3 hours already. Holy hell.
My goodness.
Denied. One word. No
Denied.
one.
Yeah, TLDR.
It's 12 pages. Oh, lordy.
12 pages? Well, that's
see, what's
a little more brief than what we're used to.
Yeah, that's true.
Oh, this is from April. This is April? Why is this in a current... What? I'm just going to skip it really fast. Granting motion to exceed pay... Oh, I've seen this thing before.
Oh, yeah. I wonder...
Don't need it.
Can I do that?
Redundant. Here's one that's 15 pages. What's this one? I was just plucking all kinds of stuff. Oh, filed June 22. That's a little more current. Let's move that over here. Kick this one to the can. Has reviewed
keep on with what you're keeping on.
Alternatively, motion and
oil change time here.
I know I've got one I've got to do as well. But someone has to do this. Motion to dismiss all filed April 14 and this ruling being April 13. Motion to dismiss constitutional authority regarding attorney discipline precludes.
That's good.
What?
We could read just "it is ordered." That's
oh, I like that part.
Yeah.
Paragraph of the briefing order stated the following: it is ordered, providing each party on the opportunity to submit simultaneously a brief on this specific issue alone. That is no more than 10 pages in length and must be filed works too, with the disciplinary clerk no later than 4 p.m. May 21. And then it seems to me that's when they filed that great big long thing, because they got leave to do so. Let's see. Despite the order's indication that the brief opportunity was simultaneous one, respondent filed a document labeled response to the state bar briefs. While reviewed, the PDJ did not consider it in this order, and it did not conform to the order, nor did respondent request and obtain relief to orders. So already we're doing it wrong. Attorney discipline clause, issue probable cause orders. Yes, this is historic information. Gingras argues that the bar seeks to discipline forum for activities protected in right as free speech and petition, and therefore he may seek dismissal under Arizona anti-SLAPP stuff. Ethical violations. He was naughty. See, this is which one's this? Oh, yes, violation of Judge Mata's order not to share stuff. Violations preclude Mike Maricini from testifying related to Judge Mata being disparaged in his comments. Violation related to responses to spreading comments about members of the public. Okay, yeah, this is just the outline. I like analysis. That's good. See, the motion relies on. So this is the other side, I guess. ARS, in which the parties seem to agree, it's a relatively new statute. And application in Arizona attorney discipline matters is a case of first impression. I wonder how they established that. PDJ notes that the statute provides that the movement has an initial burden to establish a prima facie proof that the legal action was substantially motivated by a desire to deter, retaliate against, and prevent the lawful exercise of constitutional right. I would say it doesn't apply, but I'm not a lawyer. A finding must be made that the movement has met its burden before the plaintiff, and the action is required to file a response to a motion pursuant to subsection A of the statute. PDJ has conducted a cursory review of the respondent's motion and finds that the motion is accompanied by a statement of facts and an affidavit as directed procedurally under ARS. However, before the PDJ proceeds with the substantive review of these materials for prima facie showing, the PDJ finds that a review of the applicability of ARS must be first considered. Okay, that seems reasonable. Therefore, PDJ begins her analysis with the constitutional supremacy separations of powers review. Respondent Gingras argues that the speech at issue in the state bar's complaint falls within his free speech rights and right to petition. 12. Oh, God. Let's see. Statutes of any legal action that involves a person's lawful right to pursuant to the U.S. Constitution. Intervener may file a motion to dismiss or quash the action under this section. Yeah, that's how many anti-SLAPP laws in many states, from what I've been learning.
Mm-hmm.
That's not exactly a new concept.
No.
Let's see, defines the legal term legal action as civilian and criminal prosecution, except for drug trafficking offense, Title 13, Chapter 34, right or serious offense, violent, aggravated felony, any written investigative demand pursuant to section or other compulsory. Yeah, we read that. That's the one I actually looked up. Rule 48A of Arizona Rules Supreme Court provides the nature of disciplinary proceedings are neither civil nor criminal, but are sui generis. Ooh, I love big words.
Nice.
Therefore, the PDJ holds that the disciplinary action at issue would not fall within the definition of a legal action. Ah! Ha ha! I knew it. Under ARS 12-751. Respondent Gingras argues that this case involves A3, regulatory administrative action by a state actor. While respondent does not cite the legal authority he was relying upon in typical genius fashion, douche canoe fashion, assuming such is accurate, the PDJ finds that ARS 12751 reflects that the Arizona legislature intends for this statute to apply in attorney disciplinary proceedings. Interesting. The PDJ will assume for purposes of conducting analysis that at least some of the complaint's allegations involved alleged violations of ARPC and or rules of Supreme Court for what would generally be found to be person's lawful exercise, blah, blah, blah. However, the instant case does not involve a general member of the public and their actions. Rather, the matter is centered on the state bar's pursuit for discipline of an individual licensed to practice law in the state of Arizona for alleged violations of the lawyer's obligations imposed upon lawyers by the Arizona Supreme Court's rules. Again, it seems way too reasonable.
Yeah. Something that's been in place for decades.
Yeah, if not maybe a century.
Yeah.
Whenever they were incorporated as a state, or whatever the term is. It's the constitutional authority. It is well settled matter of law. The Arizona Constitution provides the court administrative supervision over all the courts of the state, including attorney discipline. The court has consistently found that the practice of law is a matter exclusively within the authority of the judiciary. The determination of who shall practice law in Arizona and under what condition is a function placed by the state constitution in this court. See, we're trying to overthrow the state constitution. That's what he wants. In fact, the great weight of authority is in accord with the proposition that the ultimate authority for defining, regulating, and controlling the practice of law is vested in the judiciary. Citations included. To this end, the court has issued rules such as 34 regarding the admission to practice, 41, which provides duties and obligations, including oath and creed. See, there we go. That a lawyer must accept as part of admission. See, why isn't that in bold? That should be in bold.
Yeah.
If I were to pull a douche canoe. Put that in bold and italicized. See, Rule 42.
Underlined. Might as well do an underline too.
Yeah. Just do all three. The holy trinity of marking it up.
But in color too, right?
Ooh.
Yeah, it should be in red.
With graphics.
Bright red.
Yeah.
Color graphic.
These signs. That's a good.
Oh my gosh. See, Rule 42 provides ethical rules for lawyers' practice. Rule violation of 41 and 2 are subject to disciplinary proceedings pursuant to more rules. Oh, God, it's just rules upon rules. Places obligations upon a lawyer who chooses to be admitted to practice law in Arizona. Such things as the written manner, including word choice that the lawyer may use, the veracity of the statements provided by the lawyer as an officer of the court. Ding, ding, ding. Another thing that should be underlined. Comment 1 goes on to educate, quote, lawyer, whether or not engaged in the practice of law, should act honorably and treat others with courtesy and respect, end quote.
My ass.
Yeah. A person is not required to practice law in Arizona. However, my voice is running out of gas. Once one elects to do so upon admission, the person has agreed upon these directives and restrictions on one's general personal rights. Court rules provide for enforcement of responsibilities and obligations. Probable cause, finding, blah, blah, blah. Separation of powers. Okay, blah, blah, blah. More constitutional stuff. I'm going to skip it.
This is what's out there that you signed up for with us, right? They're picking out the applicable information that ties into, like, the courtesy one. Well, when you're going after Judge Mata saying what you said or wrote what you wrote, that's questionable issues for the state bar. You know.
Yes. Yes.
But instead, they're attacking the state bar's right. That is what they agreed to back then is impeding them on their First Amendment rights, which should be stronger than, you know what I mean, more important than
my opinion is that they're trying to erode the power that both the Supreme Court and the bar constitutionally have.
Yeah.
We're trying to erode that authority by claiming First Amendment issues and anti-SLAPP. We're trying to wield that as a weapon.
Yes.
Against already constitutionally granted authorities.
The establishment, put it that way.
Yeah, well, that's not surprising. Let's see court spelled that judgment. Rules adopted by the court prevail. Court favors interpretation legislation. Conclusion. See, PDJ finds the following: that movement Gingras has failed to demonstrate that the statute does not unduly hamper the court exercise of its constitutional authority. As I said, constitutional authority, not just a willy-nilly.
Yeah, regarding the practice of law in Arizona.
Yeah. Independent of such showing, the PDJ has been unable to determine how to apply the statute in a manner consistent with the court's rules regarding attorney discipline. For these reasons, it is ordered denying Respondent Gingras' motion to dismiss, filed April 14. See, given the matter of first impression and the effect of PDJ's ruling herein and provides instant case, PDJ understands that a party or both may wish to file a petition, special action. Therefore, the PDJ will not issue any additional procedure schedule in the matter. However, if petition for special action is not filed within the next 30 days, which should have expired last week, PDJ will proceed with the issuing the new procedural schedule and order in this matter. Okay, that was from last month. Wow. Seems concise to me.
Yeah.
Oh, let's see, what other goody things do I have? Oh, let's skip to those bankruptcy
in
to round off
comparison to
the
the
evening.
other blatherings about that happen to, orbit
They must
Jim
be
Grass and Ron
shared.
Daza.
It's interesting. I mean, one could spend days and years going over constitutional philosophy.
basically.
I'm not going to do it because it's just too thick for my small little head.
But you would also think there were lawyers lined out the door down the street around the corner, right? Under this argument. It's not just one. You would think they'd all say, wait a minute, my rights have been trampled.
I mean, it's an interesting proposal to put forward.
Yeah, you can argue anything, it's just how well you sell it or support it and how they interpret it. They make a decision, which I think, again, will be a one-word sentence. Denied.
Yeah.
Not even denied. Maybe they'll use 2 words.
Yeah.
Maybe it'll be the end of the week. 2 words. Motion denied.
A little respect. I got you.
What do you think of this thing, Rob? Which, we haven't heard much about the appeal in San Francisco with she who must not be named.
Behind the scenes, which obviously can't be spoken out loud because they're building cases, right, in support. My understanding is she did submit what she was supposed to submit after requesting a extension, and she did submit it, so that's now in their hands. I'm just waiting to get the new dates, right?
Yeah, this docket entry was particularly intriguing to me. Documents will not be provided in this case without formal request. Confidentiality issues may be present. So I'm wondering if there's been some other stuff filed from you-know-who. I don't want this in the public.
Yeah.
And this one's dated from the 27th. So I guess Steve, is that his name?
Yes.
Getting documents? Yeah. I would be curious what he's been observing there with this. Since last I checked, she's still not filed her appellate brief. TikTok.
Yeah, when did you submit that? I thought that's what she had to submit.
Yeah, they gave her, oh God, now I don't remember the date when she had to put it in. Because they gave her an extension for time.
Applied no more extensions, so you have to have it done by a certain date.
Yeah, no, I can't remember the dates.
Okay.
Yeah, this is not a very.
It's not full. Yeah, it's not.
Yeah, this doesn't seem like the full docket. Reason for the delay. What confidentiality issues would there be unless she's complaining?
You could talk about health issues that you can't have out in public because it's your private.
Yeah.
Okay, that makes sense. God, are we using the same tactics again?
Court, appellate court. I've got issues. I've got healthy issues that I need more time. Can we do this virtually? So I don't want to talk about the other things I'm involved in because they make me look bad, and I don't want you to know as the appeals court so that I can keep abusing Mike Maricini by filing constant DVRO requests so I can abuse him more.
But it's not confidential because
if you want proof, I'll give you my patient portal.
Oh my god.
All you have to do is request it, and I'll provide access to my patient portal.
But it's not. Oh, but it can't because it doesn't exist. Oh, okay.
So you
And
kept
I need indigency. I'm poor.
Indigent.
I'm poor
That's gonna
defenses,
save it
Laura
all.
Owens. I need indigency filing my appeal. Can I get an appellate attorney for free?
That was easy.
Yeah, I was hoping for some more news about this, but not yet.
Yeah. My tax dollars are hard at work, though, so that's good.
Yeah, I mean, too bad you can't get a return on the investment.
My condolences.
I'm glad to help. You know, anything for justice.
Doing your civic duty, Rob. That's the feather in your cap.
Yeah.
I wonder when I'm going to receive my jury duty.
I wasn't going to ask you that
Wouldn't
because
that
I'm
be
afraid of the
brilliant?
answer.
It's like everybody else. I could receive.
Yeah.
You know, I might not make it to the jury. You know, but
Not if they do a thorough screening and go, oh,
let's
Oh,
not.
it's that guy.
doesn't this guy have an order?
I-
Your face looks familiar. Have I seen you in the courthouse before?
Yeah. No, like me, I'm not a bad person whatsoever. You know what I mean? It's like
You don't have 14 felony charges hanging over your little head,
I do not.
which is very, it's admirable.
Thank you.
It seems like that's kind of a collector's item in Scottsdale, but what do I know about such things? Oh, and
makes
this
me
is
glad I
funny
don't
little
live there.
thing from yesterday. The 14th company, we talk about this briefly,
14
files
indict-
proof of claim.
Yeah.
I wanted to know what the 13 previous were, but either I missed it or they haven't listed them yet. Maybe it's on the Reddit. Submitted in the Chapter 11 bankruptcy case of Ron Owens and Jan Black / Elizabeth Ann Naylor Owens. The U.S. Bank Trust Company, acting as trustee for Colt, the horse mortgage loan trust, is claiming $1.753385 and 12 cents million secured by the primary residence mortgage in Scottsdale. The claim includes the $178,956 and 69 cents giggity in overdue payments and fees needed to bring the mortgage current.
Wow.
Oh, let's see. Did I bring that one up? I think I did. Yeah, I've got it. I did go to Volo and grab it because I wanted to see what else is here. Make it bigger.
Yep.
And biggin.
Yeah.
Oops.
This is,
No, that's off-centered and biggin. Let's move it over.
was this
See,
the one?
I hate this about this. It doesn't center things.
Yeah.
Okay, there we go. That'll do-ish. See, the perpetrators of bankruptcy, proof of claim. Okay, there's U.S. Trust, Colt Mortgage, Select Portfolio Services, Salt Lake City, Utah. So many things go to Utah. I wonder why.
Oh, taxes.
See, does anyone
Probably.
claim? Does the claim amend one already filed? No. Has anyone else filed proof of claim? No. Do you have? Oh, this is just for the creditor. How much is the claim? 1.7 million. What is the basis of the claim? Money loaned.
That's kind of generic.
See, claim secured by a lien on the property. So, ooh, yes. Oh, is all or part of the claim secured? Yes. The claim is secured by a lien on the property. How can it not go to foreclosure? We've got liens against it, for Christ's sake. And there's, never mind that, because we don't endorse people showing up at their residence, so I'll just make that disclaimer now. Real estate, if the claim is secured by the debtor's principal residence, file a mortgage proof of claim attachment. Oh, we don't have motor vehicle clicked. They could have done that too. Maybe could that be why they jettisoned the Hyundai? And we got something else.
Conveniently in somebody else's name.
Allegedly.
Allegedly.
We
but-
allegedly got a new, and I'm using air quotes, Nissan.
Yeah. But that annual interest rate, though, is that
8%.
8%.
fuck
fixed.
me.
I mean, it's bad normally. That's even.
Yeah.
Yeah.
Let's see, claim
God
based on a
damn.
lease? No. Yeah. No. Okay. Gosh. Don't wiggle your finger when you're changing it. Claim involve a right to set off? No. Is all or part of the claim entitled to priority under 11 U.S.C.? No. Oh, interesting. Okay. That may be partly priority, non-priority, some category. Okay, it's law stuff. Never mind. Taxes, penalties, wages, deposits, blah, 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 blah. Person completing this proof of claim must sign and date it. I am the creditor's attorney or authorized agent. We like that.
Mary.
Executed on 6/29/26. Mary Vitartas?
Vitartas.
Ooh, it's kind of fancy. Authorized agent for secured creditor. Company Robert N. Schultz Schneid Crane and Partners PLLC. Georgia.
Well, name.
Ooh.
Oh, well.
Alfreda, Georgia.
Yep.
That's a long ways to go for
The mortgages and servicing of that is all, it's traded all around. Like mine just got recently serviced somewhere
Oh, sweet
else.
baby Jesus, the numbers. Tiff will like this. She's probably already seen it.
Yeah.
Oh my God. Principal balance 1.58. Principal due 16,000 and change. Interest due.
Interest due 150.
Monthly mortgage payment 11/7/40/23.
God damn.
They bit the farm and then some, didn't they?
Jesus fuck. No kidding.
Interest due 154,000. Fees and costs 4,000. Escrow deficiency 5,000. Total debt 1.7. Arrearage as date of petition 16/14. Oh my God. Escrow deficiency for funds advanced. Projected escrow shortage. Less funds on hand. Total preparation, pre-petition arrearage, if I read the right words in the right order, 178,000. They're sunk.
Oh my God, they're so like
They're sunk.
Fuck, they're so
And here's the
The breakdown.
Holy
here's the whole
shit,
damn
look at
thing.
this.
Where's my Google Sheets, people? Where's my
Look at all the red.
oh my God. Delinquent taxes, suspense payment, curtailment, suspense NSF, county tax, payment due. God, this is great. This is what you don't want to see with your mortgage, folks.
There was
Unapplied funds balance, fees, charges. There's not very many fees and charges, much to my shock. Escrow balance.
I think it's such a high dollar amount that they really want to,
91 cents. Although, wait, I spoke too soon. They get bigger further down. Now we're getting the charges. Here we go. As much as about a year ago, we start getting $91.91. It's just going to highlight too much. Then $100, then $170, then $225. Then we get into the 900 and the thousands.
Those are payments? No.
No, this is fees and charges.
Ah, okay.
We start getting to fees and charges into the thousands. Oh, it's delicious. Including
I
fire
want this
insurance.
spreadsheet so badly. Oh my God.
Does this get you excited?
It's number analytics data nerd.
And it's clear and concise in the column. OCD.
Property inspection. Wow. So there's the breakdown. See, this the entity has the right to foreclose in U.S. Bank Trust Company. Not its individual class, but sole trustee, mortgage loan for. Wow.
Is this link in our show notes for all this shit?
I think so.
Okay.
Or if not, then I can add it. I can't remember. Golly, we'll check it if you want. Note, murder at Miami Beach, Scottsdale. Borrowers promised to pay in return for a loan in the amount of $1.6 million. The principal that I've received from Foundation Funding Corporation. Oh, this is their contract, isn't it?
Yeah, the last one, I guess.
It's the mortgage contract. Interest, 8%. Well, they got screwed there. They're stupid.
Yeah, if they 2054.
Yeah. I'll make these payments each month until I've paid off the principal and interest. Each monthly payment will be applied as of its scheduled due date and will be applied to interest before the principal. If on May 1st, 2054. That should be 2025, I assume. Wait, was it scheduled out to 2054 for their mortgage?
Well,
yeah. 30
yeah.
year?
Yeah, it's 30 years. Back in 24.
Holy hell.
4.
I don't know why it's circled, but I had to do the quick math.
2024. Yeah, if they. Yeah,
I will pay those amounts on that date, which is called the maturity date.
Yeah, if they
I'll make my
refied
monthly
at that
payments
point,
at
it'll
redacted.
Restart the. if they did another 30 year, then yeah, that would align.
B, amount of monthly payments, $11,740.23. This amount does not include any property taxes, insurance, or other charges I may be required to pay each month.
Who the fuck can afford that? $11,700 a month? God.
People who think they're wealthier than they are. That's how crazy they are. Borrower's right to repay, loan charges, borrower's failure to pay as required. See, if the note holder's not received... Go ahead, Rob.
It's probably all standard verbiage in this,
Yeah.
But the high dollar amounts and the lack of payments is what's blowing everybody's mind,
Mm-hmm.
If the note holder... Oh.
Go through this stage of his life. I really don't think this was his game plan whatsoever. I just can't believe it, right?
His women fucked him over.
Well, unless he's not included in this depth, because I think that would affect his health too, don't you?
I would suspect that he hasn't run the house, maybe ever.
Yeah. Or
someone else.
Yeah.
Miss Ma'am Lady, I think, has had her fingers in all the running of the finances.
Yeah.
Mm-hmm.
Which, because I think she's crazy, is why I think they're such a mess.
Men marry younger in Europe back in the day because as you get older, you have a younger wife to help take care of you. So I don't know if you realize that, but that happens a lot in Europe. And here too, you've heard of cases with Nicole, what's her face? Remember her? Old guy. It's a while ago, and I can't remember her last name. I think it was 3 names.
No, I don't know.
Yeah, okay.
Well, thank you for providing me all the justification in the world to date younger than me, Rob, because...
Yeah.
Oh, brother.
I appreciate it. Yeah.
Danny says, what is this document? This is the submission for one of their mortgages, Colt Lending.
The 14th creditor?
The 14th creditor coming forward in their Chapter 11 bankruptcy. So this is their filing to the court, shall we say, of what the Owenses owe them and what the things are. So this is all the supplemental documentation. I like that, see, if they haven't received the full amount of any monthly payment by the end of 15 calendar days after the date due, it will be charged a late charge to the note holder in the amount of 5% of overdue monthly payments.
Well, when you read all this, coming from a perspective of, well, I'm not going to pay it anyway, right? Think of it that way. Does all this really matter to you? You know?
Oh, of course.
They just wanted to get it, and they signed everything, including Sarah Owens Navarro and Christian George Alfonso Navarro.
Jesus,
that wasn't very smart of them.
Co-signing on a loan. Naughty.
Well, it's their own stupid fault. Let's see, is there anything else in here? Deed of trust.
Seems like pretty standard.
Tightly printed stuff, which I don't want to read.
Standard deed of trust.
Avoiding foreclosure. I wonder if they read that part.
Mm-hmm.
Yeah.
Mitigation losses or mitigating losses. I'll bet they didn't read that part. Yeah, this is all the rest of the legalese. Oh, which they signed. 4/22/24. Oh, Christian signed. Oh, really? The kids signed first in this one. Interesting.
Huh. Yeah.
Notary acknowledgement, New York. It's a horrific print. Maricopa County Recorder. Mortgage registration. Select Portfolio Servicing, Inc. Report notice regarding your annual escrow account disclosure statement and your new escrow payment amount.
That's pretty normal.
Yeah, it's still $12,000.
I see shit like that with my mortgage. They're once a year you're supposed to have you get a doc that reconciles your taxes and
if not, then you got to
insurance and blah blah blah.
Yeah.
Wow. Okay, now I just want to know what all the other creditors are. Oh, okay, that's all I've got tonight, gentlemen.
Huh.
Nope.
I've run out of tabs.
Good job, though.
Yeah.
That's a lot of paperwork for a few hours. Woo!
Yeah.
I'm thanking God that we were here, G. Oh, lucky we're here to help him.
Yes, thank you for the help, boys.
Yeah. Despite his bitching earlier about me like distracting him, but again, that's what I do.
I am agreeing with Helville. Ron he's had his fingers in things. Not quite, I don't think, to the extent Mommy Dearest and Laura have, and maybe even Sister Sarah. Now that we know that Sister Sarah has apparently, allegedly, been a money pass-through for them, I think we've got some women issues in the Owens family. Running amok.
I think that it is, Ron is, he's the enabler. Like, I think that there's this thing where...
I think he's a passive enabler, though.
Well, yeah, but because, like, Elizabeth and his daughters, Laura in particular, just, like, steamroll over him, and he's just like, okay, yeah, I'll just do it, you know,
I think now, because of his low energy health status, what else is he going to do? He's not going to fight them.
But not,
yeah.
Remember July 4th?
Yeah.
Vibrant, it seemed. But again, with all those issues and the things he's battled throughout his life, this is not where he should be, right?
Well, no. You would think at this time and age and medical issues, he would be, you know, enjoying his retirement.
Fighting to keep this extremely large home that's more than he needs, correct? That you get pay off something smaller and live comfortably with the income, you know, because they do bring in quite a bit.
$21,000 a month.
Think about it. Put yourself in those shoes. You would live differently, wouldn't you?
Yeah, I would. Shit.
Echo's needs are very high. He's high end.
Well,
I'm high maintenance.
He's high goddamn maintenance. Part of that is all the repairs to his fucking car because he's like, apparently his neighbors like to play bumper cars with him when he's out and about driving.
They go for him, yeah.
Yeah. But
Danny earlier raised the point that Ron was a gambler, though. But that's not where all of his money went, because Tiff has done some snooping into that.
So let me ask you this. There's also online gambling. Many years. Who's to stay laying there bored? Dip a little into that.
Yeah.
And not just him, other people too. You know what I mean? It's that accessible these days.
Right. But I mean, I look at what I currently pull in working for Corporate Daddy, and I have found a way to manage my finances with making well under less than half of what they bring in every month.
Right. But it's called a budget, and you stick to that budget.
Yes.
And you have some cushion, obviously. But
sure, yeah.
Is getting out of hand. Hello, financial advisor. Hello, right? That's you got to do something. You don't really get to the extent that some people do. You know,
and it doesn't even take a financial advisor, right? It takes like just signing up for YNAB.
Right. Yeah.
Like it's not that fucking hard.
And you start with a spreadsheet. This is what I pay every month. List it down there. Then put the down. And that'll give you now. This is what we need to make. You know what I mean? And bring in.
But if I brought into my household $21,000 a month, if that was like, if that's literally what's deposited into my checking account every month, how on God's green earth would I can't conceive of a way in which I would be in a situation where I'm like fighting with my mortgage company to like barely hang on to my house and be $170 some odd $1,000 in the rear.
And with that 21 coming in, what was it?
Fuck?
11,000 in the payment and the loan for the house. So that's half gone right there. If they were,
11 or 12K just gone.
So that's why you don't buy a house like that. It's out of your price range. You know what I mean?
Right.
You don't get a mortgage for things you can't pay back in the monthly.
And I get that diesel's expensive, and I love my diesel toys, as you know, Echoes is want to fucking mock me for with all of my, you know, vehicles and shit. But like,
it's your choice, and you buy them to afford them. You wouldn't buy them if you could afford it, right?
I couldn't, and I wouldn't. Yeah, if I couldn't afford the insurance, and I couldn't, like, if I had the payments, I wouldn't, you know, whatever. But like, I just don't understand how that's like even a thing. I just don't.
That's a long time coming, because it seems like a lot of phone calls and pity B may have occurred, And for whatever reason, people allow it to continue on instead of saying no.
Yeah.
Period. This is it.
And to your point earlier, I think that like Ron is like the ultimate enabler of these women.
Yeah.
Like, and it's not, I really don't want to sound like a misogynist or anything, but like, I feel like they are steamrolling him and just taking complete advantage of all of that. As much as I'm sure he's culpable in a lot of ways, but like they seem like Jan Elizabeth, whatever the fuck she wants to call herself, she's such the conniving, like, I'm going to manipulate and I'm going to like suck all of this, like, she's all about her, you know, and like Ron's just probably in a spot with his medical conditions where he's just like, oh, okay, honey, I'll just do whatever, you know, and like,
what can he do? He can't drive.
What can he do?
And at home and at their, you know, whatever they decide, he has to do it. So
right.
keep do, you know, but I'm sure he's spoken up. He's aware of things. So, but what can he do?
Maybe. But even look at like the bankruptcy hearing that Echoes and I covered in the last time we got together. Like he barely spoke, and every time it was just acquiescing to her.
And just at the beginning of that, Jennifer asked them both to answer. Remember?
Mm-hmm.
Like you both answer. And
yeah. And she said it was very clear of like, Ron, you need to, if you don't say anything, you agree, but you are enabled and entitled to speak up and say, I disagree with that statement. So even if Elizabeth went off on a fucking crazy tangent and Ron was like, I don't know. Like he could have like totally spoke up. Did he? No. It's like, he's a fucking cock.
They are one and the same in the situation, both and separate, right? They're both accountable.
Yes. But even with license to speak up and say like, no, I don't agree with that narrative. He just totally like bent over.
Yeah. But keep in mind, you're sitting there on a phone call in a room where someone might be hushing you. Mm-hmm. You don't understand, mute the phone. Something you don't know.
Somebody could be like literally with their hand on their thigh, just going like, you know, and
let me do. In any case, you know,
maybe Elizabeth on, you know, his nearly dead nards or something, you know, just like, you know, but.
Oh, the poor people! Whatever are they going to do with themselves?
It just.
Time will tell.
Yeah, we get to watch this shit show continue as it flows downhill. What else can they do?
Yeah, justice should prevail.
Justice should prevail.
And I've got some family members who are like they're older, so they sort of fall into that stereotype of like the conditions in which they were raised and sort of like roles and like the husbands are supposed to do XYZ and the wives are supposed to do XYZ, and those dynamics are flipped a little bit where it's, you know, my aunt-in-law, I suppose, is like very much the pants wearer, you know, like, but my actual uncle is the, like, he earned the money and earned the right for her to, you know, live the life that she wanted, etc. And like, but it doesn't stop her from sort of just like controlling the entirety of the landscape of it, you know, and like, fine, if that's how they want to live, that's great. But I mean, it's not unheard of that just like the wife figure is like holding all the freaking purse strings. I mean, the joke is about, you know, like having the balls in the purse and whatever. But yeah, like, I mean, that's how they want to do it. That's how they want to do it.
Whether it be at one point the husband, another point the wife, you know, it all depends what's going on in the situation.
Sure.
But
and I don't know all, to be fair, I don't know all of their agreements. I mean,
no, but think of all the things we are aware of that's public knowledge, right? How do you juggle all of that? The entire, what do you call it? What verse? It's the verse.
The Owens verse.
The Owen, LOU, the Loa. That's, yeah.
There's a lot of balls in the air, you know? It got to be taking its toll physically on everybody. I think.
Oh, I'm sure.
You know. But how do you keep going? That's what blows my mind. It's like
psychosis does that.
Yeah.
Pack. Garage sale, pack, do all that. Be prepared. You don't have to move if you don't end up keeping it, but be prepared in case that does occur. Because inevitably, I can't see those dollars working out.
It doesn't. I mean, if their monthly bleed out is anywhere near accurate what they put in the documentation, which I feel like a lot of that shit is just like completely made up. But like, who can't survive and sustain their life on literally getting a deposit in their checking account with $21,000 every month? I could pay for Echoes' life if I had that kind of money coming in.
Yes, please.
Yeah.
Shut up. No, it's going to come with some strings attached, and you're not willing to do those.
Well, how
strings.
about spaghetti attached?
How about some pot roast occasionally?
Right?
Yeah, I've got a pork tenderloin. The bacon pork tenderloins are fantastic.
There you go.
Mom's Biscotti.
You have yet to invite me over for that.
Mom's Biscotti says, I'm just so curious if how this potentially impacts Laura's indictment bond, because we all know there's fuckery afoot. Well, until they untangle the comminglement, and I'm not so sure the DOJ trustee will dig that much. If and or when they decide to and see how much has been commingled in Laura's direction that she's filed for indigency about, and that may or may not be true. Until they get that far, I don't see the nexus yet, but they may not.
Series gifts from her parents, remember? That's what she said. Gifts, yeah, it's a title to label it. And so you got that going on. And
no, it's income in kind for her services rendered to be the face of the family company.
The face of the business, yeah.
Like Shirley Temple on a bottle of syrup or something. I don't know.
No, it's more like whatever happened to Baby Jane.
Oh.
Betty Davis was awesome looking in that movie.
Yeah.
But it does make you stop and think. The whole picture, it's got to come to a busted sooner.
The House of Cards surely must come tumbling down at some point.
Yeah.
Like,
who knows, right?
How? I just, how can I and I don't know, maybe this is a little like rose-colored glasses of me a little bit, but I just don't understand how the grift can last this long and
continue.
And right. And continue into perpetuity. Like, how many times can you kick the can down the road? How many times can you delay these court proceedings and all? I just.
But you can. That's what the law is allowing.
Yeah.
There are new laws. There are laws that we haven't even aware of that we're thinking of that they or will be using. You know. So and that's good. Yeah. I mean, so we all should have the same right. That'd be cool.
Yes.
I can't take that away from anybody, but you just see the writing on the wall. It just seems so blatantly obvious, you know.
Yeah, I mean, it's very clear that Elizabeth prioritized, like the reason why she prioritized paying the life insurance bill. Like that should tell you everything you need to know.
You can, that's just blatantly obvious.
Right there.
People have been saying that for months.
Well, yeah.
Someone rather less tastefully said, they're just trying to kill off Ron to get the insurance. But I don't think they were wrong.
They're not.
Or they know about his more about his medical condition that we know that he made a limited time. I don't know.
Yeah, maybe.
Yeah, I've been saying for a while, he's clearly not in the best of health, but he's not clearly dead yet. So they're biding their time and just trying to delay things until they can find another funding source to dig their way out again.
Live that way. I took care of my mom for 15 years, and there was nothing at the end.
That's just such a shit thing to do. Like, Rob, you taking care of your mom, like altruistically and like making sure that like everything was taken care of. Like I've got plenty of family members who have done the same thing with
From the
moms
heart.
and husbands and whatever, right? Like you do what you got to do.
Yeah.
But to kick the can down various roads to try and abuse and or manipulate or take advantage of a life insurance policy or pensions and that sort of stuff, like that, just to preserve somebody's life for, a thing or
His benefit anyway. He won't benefit from it. That's the hardest part for me to
it's just
absorb.
Yeah, and the only point that I empathized with Elizabeth when she was talking about the life insurance policy is, yes, if you got that policy a long time ago, and that's the premium you pay, like, yeah, it's really goddamn expensive to reinstate a policy.
And it's hard to give it up. I
Yeah.
understand.
I get it.
But if you're in a situation that we are aware of, it might not be worth keeping it going because it's going to cause you more friction, more trouble with, even a bankruptcy court or just in general.
Yeah.
You got to pay your bills. The mortgage really come first, and it shouldn't be that high. They should have really chosen something a little less expensive, so that's where they can put money away, not have overspending per month. You know what I mean?
Right. Yeah. And again, I keep going back to their monthly income, but I mean, fuck me if they were getting that kind of money and yet they're $170K in the rears, it's like, why wouldn't you aggressively work to sell the place and get a smaller house that you can either just like pay cash for or like adjust your budget?
Good point, Helville.
But it's like, yeah, and Helville's point is super accurate around like not just the insurance part of it, but also like they were choosing to pay some portion of their fucking Macy's credit card at 32% interest.
Yeah.
Because you had to buy an outfit to go to fucking court? Like, come on.
Reason. That's a lot of interest on money outstanding. And, don't let it get that far. I'm sorry. There's certain things in life you don't have to have, right? That's why Jennifer was focused on your daily living. What are the basic things? Basic living doesn't sound like they understand what that truly means.
Yeah, they don't. They don't understand the cadence of or what it takes to actually just manage from a day-to-day or month-to-month basis of like, okay, this is what I have coming in. These dollars need certain jobs, to use YNAB parlance. Like
this is everything going out. What can we remove? Because we got to meet that.
Well, what's your priority for this month, for the money that I actually have in my accounts and I have coming in now, not in the future, but now? What does that money need to do?
Is it fair? It's been 12, 18 months. No mortgage has been paid.
Yeah.
So that's 12,000 times how many months would be in the bank?
Yeah.
Right? Or accounted for. Where did it? Just that simple fact right there versus everything else. But that's a lot of money.
I mean, I'm going to whip out the calculator real quick. And we do let's just do nice round numbers of 175 in the rear. And 12,000 a month. I mean, that's 14 and a half months worth of not paying your that's over a year of not paying your fucking mortgage.
But where did the money go? It should be in there because you filed for bankruptcy. So anything going forward should still be saved in the account, right? I mean, that's the appropriate.
You would think.
Yeah, I would think. But the numbers that we've seen, it doesn't show that. But again, we don't know everything. We aren't privy to everything,
Sure.
But it does
the stuff that's in the documents and things that we have seen in the filings, the 13 and the 11.
Yes.
It's like, that's shining an awful lot of sunlight on some of this stuff.
And your bank statements that you provided me, you've spent over $500,000 in X amount of months, a year and a half, whatever.
Mm-hmm.
And I seem shocked at that. And I'm like, it's your bank statements. You know what I mean?
It's and they perpetuate that life. The I have to keep the horses up. I've got to do this, and I've got to do that, and I've got to pay for this, and like the jokes aside about the Macy's bills and whatever else. But it's like, how much like their life, the life insurance payment was like what, $2,700 ish,
approximately, yeah.
And like, what percentage of that is out of 21K?
Right. That's a drop in the bucket when you're talking 21K per month.
Exactly. Right? It's like what, and then the lease on the horse or whatever that like somebody had some kind of quote income on or what. The math doesn't math.
Right.
And exactly.
Businesses.
It just really doesn't.
Better at it, running multiple businesses.
Yeah.
Or learn from those mistakes to do better the next time.
Yeah. I mean, and like for me, like if I was that destitute, and let's say I needed to go get like, I don't know, a shirt and tie or something for court. I am not the first place I'm going to go. Probably not Brooks Brothers. Probably going to go to like K&G, or like, yeah, or Joseph A. Banks. I'm not going to go and get the $2,000 suit. I'm probably going to look to the $200 one.
Right. That's a good example. Still meets your needs. Just don't need just
It's going to be a suit and fucking tie. I mean, it's not going to be like bougie with fucking cufflinks and stuff like that. But, I don't know. I've had my fair share of times in my life where I've been broke as fuck. And like, I let, $400, $500, $600 credit card thing ruin my credit. No. But I also wasn't making the same what I am now, nor was I making 5 fucking figures a month to let that ruin everything. I
do assume you learn from that. When you go that far down and you build yourself back up, you choose not to ever be there again. I assume.
Oh my God.
Yeah. It was depleting, and you're like, I will not do this ever again. I'll watch everything.
Oh my God, no. And like, I mean, that is even just talking with my therapist about this last few sessions of like, I don't want, like, if I'm ever to get into an actual relationship, it's like, there's a thing about my risk profile. And like, I've worked so fucking hard to dig myself out of the 5 figures debt that I was in.
Right.
To this point where the only debt that I have is my house. And if I get into a relationship with somebody, then what's the risk of like taking on that additional burden or that additional like debt load, et cetera, to do the things, that like relationshipy, whatever sort of things. And it's like, oh my God, like
it deters you from getting in a relationship because in a relationship, not have fun, enjoy yourself, whatever.
Yeah.
And you could fall in that trap. But, that's a difficult situation to be in. So I understand, and again, if you were bringing in 21,000, it'd be no big deal.
For my current lifestyle, certainly.
Yeah, exactly.
If I had that kind of income, then maybe I would be considering a different, like, place to live that, I might be able to store all my toys and shit and do, other hobbies and things. But I mean, for fuck's sake, like,
right.
I would probably still need to strong arm Echoes to go rent the fucking room above the garage.
Well, he of course would step up for you.
Of course he would.
Of course he would. No word from Echo.
Yeah, blink, blink, blink.
Okay. I need blinky cartoon noises. Blink, blink, blink.
There you go.
Yeah. All I heard was that just
the crickets.
But like, I just wouldn't, I don't know. It just doesn't conceive to me that like that's even a possibility, but I don't know. Maybe I'm not coming from an entitled perspective.
Right.
Like
yeah.
these people are.
You did not, it's like Prince Edward or something, right? It's like, that's all that grew up in that environment. So they wouldn't really know any different. And it sounds bad when they talk about it, but it's like, you really got to put yourself in those shoes to realize what it's like. You know?
Yeah. And I just simply can't with that type. I just, with those numbers that they were talking about in the bankruptcy hearings and on the paper and everything, it's like, I just don't know how you can fuck it up so badly with that kind of resources at your disposal. Yeah. I just don't. Yeah. But then again, there's a reason why on TLC you can watch My Lotto Life, where people get, $1 billion, like $40 million for the next 25 years, and they completely fuck their life right into the ground.
Yeah, I hear you. And I always tell people, just take the payments. Take the payments over 20 years. That way you can't.
Yeah.
Because then you have to wait till the next year to get the next one, but at least it's coming. You can breathe, But a lump sum, if you're not a financial person, you definitely could fall into hard times, right?
Who with if you want a 1 point something billion dollar thing, like if you think about like the actual like annual income, that's going to be somewhere between 30 and 40 million a year. And you can't fucking breathe or deal with that
and the interest, if you
what the fuck?
The interest, you don't have to touch the principal.
Yeah, you could put that in some high yield savings and just be like, live the fuck off of that. Like, oh my God, that's better than flipping burgers at your local Wendy's, or like, come on.
Do that too if you want. You get out.
Shit.
But it's not like a mandatory job you got to have to pay your bills. But that'd be fun. Right? You can have fun working at Wendy's or Taco Bell. Think about it.
Yeah, sure.
Yeah, the pressure's off you.
I just don't understand. I don't understand.
It really is. And you go to a certain point and you're like, God, I wish them well. I just wish them well.
Good luck.
Good luck. Right. In general. Even though things may have happened to them by themselves to themselves, right? That kind of thing. You wish for anybody. God, get out of it. That's why I think the letting the house go and finding a nice place to stay and buy it outright so you don't even have a monthly payment.
Yeah. The only thing you have to worry about is paying your fucking utilities and taxes at that point. Like, come on.
From the couch watching sports to the backyard pool. You know what I mean? Like,
right.
Right? No, I don't feel like getting up. Oh, come on, let's go. That would be okay. I can live with that,
Yeah. I mean, a good friend of mine did well in his career, and like they were able to pay off their house, well within the 30-year mortgage when they took it out. And like they've been basically debt free. And I occasionally hear him bellyache about, oh, my taxes, and I got to pay that, and I got to pay my insurance and stuff. And I'm just like, how fortunate are you?
We are humans.
Shut your fucking hole.
Right. They always have to have something.
Yeah. It's like this. I mean, it's the same, like, it's a similar thing when I tell Echoes to shut his pie hole. It's just like, come on, really? Like,
speaking of shutting pie holes, we're quickly broaching 4 hours, and I'd like to close this thing out at some point.
Would you now?
I would.
I'm sorry. Fine. I'm still sorry.
Rob still has a couple more hours in him.
Well, so yeah.
Anyway, rants aside, this was a pretty mild Jeep Daddy rant, but it was a slow roll over many minutes here. So
I hope I did not derail too much. I enjoyed myself. That makes you guys feel good.
We derail ourselves plenty.
Yes.
We just like people, pointing and laughing at us while we do it.
Yeah, if it's not you, and I swear to God, if we ever get like if you have you and like Hellville on all at once,
oh my,
and then God forbid that we actually have Llama and or Buffy on, like,
I can have a whole room full.
This is going to be this will be a marathon.
Yes, we will go off on tangents.
Oh my God.
Yeah, but don't plan a topic. Just invite us all in.
Go. Yeah.
Yeah.
Well,
Here's a couple-
Llama said she wanted to do more with us at some point.
Well, that's good.
Here's a couple docs, and we just go off on fucking rants and,
20, 30 minutes, hour later.
Oh, God. Clear my schedule.
Oh, my God.
Boom. Everybody's got to talk about the weather where they're at.
Oh, my God, yeah.
So if I invited you guys and them on my channel, that I could host, because I don't know if it's a big deal.
Right.
Do you care to host, or it doesn't matter? Or we can all do a stream.
Yeah, if we all can multi-stream it, we could all zip it out on our channels.
I think that too. Yeah.
That depends on the settings, of the each host, but
yeah, busy.
That's why I allow mine. It's like you're here, send it out to your stuff. Why not?
Yeah.
You guys,
rising tide floats all boats.
Are you
Unless
busy?
they have holes in them.
Let's do an August 6th stream.
Oh my God.
I'm sorry, August 6th?
In the evening. Yeah, after the
following the bankruptcy. The next bankruptcy hearing.
God, that's like a work night, though.
I know.
Pivotal moment in life, right? It'll be quite interesting.
And actually, I'm going to have my piano tuned on the day after, so I have to have enough energy to pull the fucking player stack out of the damn thing before the tech gets here.
We have way
That's what you get for having one.
Shut up! You're supposed to be here and supervise.
No, I'm busy.
You're busy. Okay.
Workday.
Play hooky.
Damn it!
Fuck! Call in sick or something. Shit.
I wish. I'm trying to finish a job. Never mind.
God.
Yeah, don't get there yet. Enjoy your night.
Too many fucking excuses. See what I have to put up with, Rob? Just so many fucking excuses coming out of his pie hole.
Wine. Oh, God. Okay, let's close this thing out because I don't want to be up all night. So what I'm going to do is, to make this easier for myself, is take these lovely gentlemen down and thank them for bringing themselves here tonight to slog through a bunch of crap and to close it out. Because we talked about some bankruptcy. Let's do this little thing. Everyone likes the bankruptcy Bob.
Because he helped me answer that question. David?
In the end of the video, you were talking about, Laura, I hope that you never pay Clayton. You could file a bankruptcy. Either way, there's no legal requirement for you to post bond if you don't have the money to be collected. Didn't Laura admit to having $200,000? Where did that money go? What do you mean she doesn't have any money? You don't want her to pay? You're telling your client, hey, ignore this payment of $150,000.
Maybe David could offer some clarification because he helped me answer that question. David?
Laura does not have any money, okay?
I mean, I haven't ever in my life had like a 1099 or W-2 job, really been supported by my family.
Her income has basically been destroyed, and she blames JFC for this. She says that JFC has, harassed her podcast advertisers to the point that they won't work with her anymore. And her income is basically zero now. And she never said that she made $200,000. What she said was that was what the podcast made, and she split that with her mom.
Testified on March 1st, 2024, that the horse business, Quartet, made $144,000 of income, and that was split between you and your mom. Do you recall testifying to that?
So the $200,000 that she said at the trial, she no longer has for whatever reason.
She was saying that was her income from the podcast that she was doing with her mom.
But you didn't report that on your bankruptcy, your sworn bankruptcy.
Her income is zero, basically zero. Her assets, they are what they are. Clayton is entitled to go and look for that. Dude, he can collect his judgment all he wants.
Maybe David could offer some clarification because he helped me answer that question. David?
I said to her a while ago, just if you file bankruptcy, you don't have to deal with this anymore. You just push that red button on your desk that says, boop, I'm done, bankruptcy. The entire case goes away. Clayton's ability to do anything to her in court anymore stops the minute she files bankruptcy. And she won't do it. And she said, I'm not going to do that, as much as it would bring her relief.
Maybe David could offer some clarification because he helped me answer that question. David?
But don't say that I'm encouraging her to ignore an order. She's not sitting on $10 million in cash, and I'm just saying to her, go hide that. She doesn't have the money.
Maybe David could offer some clarification because he helped me answer that question. David?
Don't say that I'm encouraging her to ignore an order. I said to her a while ago, just if you file bankruptcy, you don't have to deal with this anymore. You just push that red button on your desk that says, boop, I'm done, bankruptcy. The entire case goes away. Don't say that I'm encouraging her to ignore an order. If you file bankruptcy, you don't have to deal with this anymore. And she said, I'm not going to do that as much as it would bring her relief.
But you didn't report that on your bankruptcy, your sworn bankruptcy statement.
And she said, I'm not going to do that. And she said, I'm not going to do that. And she said, I'm not going to do that.
David was my attorney. David signed the pleading.
The fact of the matter is you authorized him to sign attesting that this was truthful, but it turns out it's not.
She has become a friend. I talk to her often. I have spent a lot of time with her, way more. I mean, you guys have no knowledge that I do as far as contacting with her personally.
Maybe David could offer some clarification because he helped me answer that question. David?
I talk to her often. I have spent a lot of time with her.
David was my attorney. David signed the pleading.
I have spent a lot of time with her.
The fact of the matter is you authorized him to sign attesting that this was truthful, but it turns out it's not.
Maybe David could offer some clarification because he helped me answer that question. David? 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 David?